Items on our agenda for today. First is the consideration and approval of the substitute bill on the Digital Nomad Visa Act. The bill is the product of the technical working group headed by Vice Chair Loreto Acharon, who is here with us today. The chair would also like to inform the body that another bill, House Bill number 10912, was filed by Representative Pablo John Garcia, and it was to refer to the committee after the creation of the TWG. Therefore, at the proper time, the chair would call on Representative Garcia or his authorized representative to formally sponsor the measure before the committee. We have invited other members of the TWG representing the DOJ, the DFA, the DICT, the DOT, and the Bureau of Immigration in case any member would wish to clarify any issue with regard to the bill. The next two items in the agenda involve bills that are the product of an unprecedented inquiry in aid of legislation being conducted by four standing committees: the Committee on Dangerous Drugs, the Committee on Human Rights, the Committee on Public Order and Safety, and the Committee on Public Accounts, more popularly known as the Quadcom. After extensive deliberations that sometimes lasted until midnight, after hearing the testimony of witnesses under oath, and after receiving numerous documentary evidence, the chairpersons and members of the Quadcom filed remedial measures that would protect the right to life, liberty, and property of Filipino citizens and penalize those who would violate such rights. The first such measure is the Civil Forfeiture Act, which aims to provide for an expedited proceeding to revert back to the state properties that are for the exclusive use of Filipino citizens but have been acquired by foreign entities or individuals through illegal and fraudulent means. We have invited resource persons from the Office of the Court Administrator of the Supreme Court, the DOJ, the DILG, the DOF, the Department of Agrarian Reform, the OSG, the Anti-Money Laundering Council, and the Land Registration Authority to give their comments on the bill. Second, the chairpersons and members of the Quadcom also filed House Bill number 10986, or the Anti-Extrajudicial Killing Act. This bill seeks to define extrajudicial killings and impose penalties on those who would commit such a crime. It also provides for the compensation for the victims of extrajudicial killings and their families. Our job here today in this committee is to deliberate on the technical aspects of these measures to ensure that the intent of the authors who filed this bill will be reflected in the final version to be submitted by this committee to plenary. We have also invited legal experts and representatives from various government agencies in order to hear their comments and recommendations. We also hope that the members of the committee will provide their inputs on the bill in order to make the proposed measures responsive to the findings of the Quadcom in their marathon hearings. Thank you very much. At this point, the committee secretary is directed to acknowledge the presence of our regular and ex-officio members present today, as well as our invited guests and resource persons.
Pablo John Garcia.
As mentioned earlier in my opening remarks, the House bill filed by Congressman Pablo John Garcia was referred to the committee after the creation of the TWG, so he did not get a chance to sponsor his bill. However, he's not here with us today.
Madam Chair,
Yes, Kong.
given the absence of the author, on behalf of the author Pablo John Garcia, I move that the explanatory note of House Bill number 10912 be adopted as the sponsorship speech for the said measure. I so move, Madam Chair.
That's noted, Kong Ton. And now we would like to ask you to present the output of the TWG as the TWG chair, Vice Chair Acharon.
Thank you, Madam Chair. Good morning, Madam Chair, other colleagues. Good morning also our distinguished resource persons. It is my honor and privilege to present before this committee the output of the technical working group, which is the substitute bill to House Bill numbers 8165 9766 and 10912, entitled An Act Establishing the Requirements, Conditions, Benefits, and Incentives for Acquiring a Digital Nomad Visa and Appropriating Funds therefor. The substitute bill is a product of technical working group meetings, actually two, Madam Chair, held on March 13 and December 5, 2024. This must be December 5, 2023. 2023. Yes, December 5. I'm sorry. Where the provisions were extensively discussed in the final version crafted in its present form. But before I proceed to the highlights of the bill, I would like to inform the good author of House Bill 10912, unfortunately not here, that the technical working group took into consideration his bill even though it was filed and referred to the committee after the TWG meeting was conducted. In fact, some of the provisions in the final version initially came from the bill of Representative Garcia. In other words, Madam Chair, this substitute bill fully considered all the measures to come up with a consolidated version for approval today. So, without ado, I would now like to present the highlights of the substitute bill, dear colleagues and Madam Chair, in a manner section by section, excepting only the short title, which is which I assume there is no more issue on that, because that is agreed to be known as the Digital Nomad Visa Act. Now, on the second issue is on the definition of terms. The TWG added the definition of a client or employer to be consistent with the definition of employment under the present provisions of the Labor Code. The intent is for a digital nomad to be gainfully employed or to be performing work or services for a client or employer based abroad. This is consistent also with the definition of a digital nomad and to prevent any foreigner from exploiting this new visa category for illegal means. Number two, the technical working group also added the definition of information and communications technology, which was, by the way, approved by the DICT, and this emphasizes the requirement that a digital nomad must be performing work or services for a foreign client or employer through information and communications technology. Number three, on Section 4, the TWG approved the main subject of the bill, which is the digital nomad visa. This visa is valid for a period of 12 months or 1 year, renewable for another 12 months, subject to the requirements and conditions provided in the Act. The provisions or conditions are already in the said measure. Number 4, Section 5, which provides for the qualifications of a digital nomad, made a clarification that qualifications are personal to the applicant, who must possess all these qualifications when applying for a digital nomad visa and must continue to possess in order for the digital nomad visa to remain valid. Number 5, in Section 6, which provides for the requirements have to be submitted by the applicant. It requires the submission of a proof of employment, income, and health insurance coverage. It also requires proof of no criminal record in the applicant's home country, in a written undertaking subscribed under oath that the applicant will not engage in gainful employment in the Philippines and will not commit illegal activities or break any laws in the Philippines. And finally, it provides that other requirements may be imposed, but only through the implementing rules and regulations of the law. Number 6, Section 7 provides for the conditions for the continued stay of a foreigner under a digital nomad visa. It also mandates that the digital nomad should comply with the annual reporting requirement of the Bureau of Immigration. Section 7, or Section number 7, Section 8 lays down the option for foreigners under a temporary visitor's visa or a tourist visa to apply for conversion to a digital nomad visa, provided that the foreigner must possess all of the qualifications and must submit all the requirements provided in the law. It also states that a foreigner who has successfully applied for a conversion to a digital nomad must comply with all of the conditions set forth in the law. Number 8. Section 9 grants a digital nomad the privilege to exit and re-enter the Philippines without the need to secure additional permits for the duration of the validity of the digital nomad visa. This is one of the benefits granted to digital nomads to entice them to come to the country and work remotely while enjoying our beautiful tourist destinations. Number 9, Section 10 also grants another incentive, which is to ensure that any income the digital nomad receives from their client or employer abroad will not be subject to tax in this country. Number 10, Section 11 provides for the cancellation of a digital nomad for any violation of this law and any other law in the country. Or I'm referring to the Philippines. Number 11, Section 12, which is the reciprocity provision. It mandates the DFA to maintain, regularly update, and share with the Department of Tourism and the Bureau of Immigration a list of countries that grants Filipinos the same rights, benefits, and privileges provided in our digital nomad visa law. And finally, Section 13, which is the Digital Nomad Visa Register, mandates that the Bureau of Immigration, in coordination with the DFA, or the Department of Foreign Affairs, the DICT, and the DOT, to maintain a digital nomad visa register for monitoring and compliance with the provisions of this bill. So, Madam Chair, my dear colleagues, with these provisions in place, the TWG, which this representation humbly chairs, believes that we will be able to entice foreigners who work and derive their income purely through online means to come and visit the country and enjoy the beautiful sights of the Philippines and experience the world-famous hospitality of Filipinos. This bill also provides ample safeguards or protection to ensure that only those who are qualified are allowed to enter the country using a digital nomad visa, and to prevent unscrupulous individuals from taking advantage of the benefits provided in this measure for nefarious purposes. So, with all the foregoing considered, I earnestly seek the committee's approval of this bill and the corresponding committee report. Thank you, Madam Chair. Thank you, dear colleagues.
I would like to thank the TWG Chair, Vice Chair Acharon, and the TWG member, Congressman Bingo Matugas, for working hard on coming up with the substitute bill. But before we take action on the substitute bill, I would like to ask if there are members who would like to ask questions or comments on the bill. If there's none, is there any resource person? Yes, Congress Ned.
Madam Chair, this is not a question, but rather, I believe that with extensive studies, time given by the technical working group, and after considering all the bills filed, even after the technical working group, as mentioned by the chairman, that it was also considered in finalizing this technical working group report. I believe that, and considering further, that the same is only being granted to the countries that offers the same benefits to our citizens. I support the report of the chair of the technical working group, and
Thank you, Congressman Fresnedi. Any other members? If there's none, we would like to ask the resource persons present if they wish to give their final remarks on the measure. From the DFA.
Good morning, Madam Chair, esteemed colleagues in the government. We would like to just comment and propose a slight tweaking in section on the digital nomad visa. Hold on, please. Because it does not specify which is section 3. Hold on, please. Okay, section 4, digital nomad visa. An alien who is gainfully employed in a country other than the Republic of the Philippines or who otherwise performs remote work for a client or employer not a citizen of the Republic of the Philippines or not registered pursuant to the Philippine laws may apply for and be granted a digital nomad visa to stay in the Philippines by the Department of Foreign Affairs through its foreign service posts. If you could please consider this.
I believe this was already taken up in the TWG. Yes. Yes,
Yes, Madam Chair, it was taken up together with considered with all the recommendations.
Yes, because it's not clear who is the issuing authority here. It will be issued from abroad, right?
Oh, bingo. Can you hear from the audience?
Yes, Madam Chair. The issuing in the original bill, we proposed that the issuing authority will be the immigration authority, and considering that there's a reciprocity provision under Section 9, under Section 12, I propose that the recommendation of the Department of Foreign Affairs is
Already
considered.
Yes,
But
already considered.
I think they want that it will be specified. Yes, ma'am. Was that your question?
Yes, sir, because it's not clear who will be issuing. There is a provision on conversion upon arrival, which the DFA in principle does not oppose. It is within the purview of the Bureau of Immigration. But if it's, foreigners coming in from abroad, of course, they will apply for the appropriate visa because they're coming in from abroad.
Yes.
So we have already conveyed this in our position paper that the DFA, to its Foreign Service Post, be the one to issue digital nomad visas from abroad.
Yeah.
And we submitted our position paper on this. And in fact, also we were asked by the Office of the President, the PMS, to provide the procedures and the requirements, and I believe this came from us. The requirements and the procedures we have provided also. And the study, we conducted a study. So, thank you.
Thank you very much.
Madam Chair.
Madam Chair, yes, I'm agreeable with what.
I think Kong Ton has a comment.
Madam Chair, there is no specific statement regarding that as raised by the DFA because that is the existing policy, I suppose, Madam Chair. And we would not need to have it restated in this particular measure because that is the existing provision. It would really be the DFA which would be issuing as it is being done at present.
We will just retain what is the pleasure of the author.
Yes, Madam Chair, I think that can be placed in the IRR once this bill is passed.
Okay. Anyway, your comment is noted.
Okay.
Any other,
Thank you, thank you.
from the Department of Tourism, do you have any comments before we
Thank you, Madam
act
Chair.
on the substitute bill? Yes.
Madam Chair, the Department of Tourism interposes no objection, and we fully support the bill to be passed. We believe that the provisions stated on the draft bill are already included in our positions, and we believe that this draft already competitively enough to promote digital tourism within our ASEAN neighbors. Thank you, Madam Chair.
Thank you. Anyone from the ICT? Wala. So, the ICT wala. Okay, so, BI wala rin. BI?
Good morning, Your Honor. The Bureau of Immigration does not interpose any objection and fully support the passing of this bill.
Okay. So now the floor is now open for any motion.
Yes, Madam Chair. Madam Chair, I move for the approval of this substitute bill to House Bill number 8165, 9766, and 10912, and the corresponding committee report, taking into consideration, Madam Chair, the statement from the DFA representative and subject to form and style, Madam Chair. I so move, Madam Chair.
Is there any objection? We're already approving the we're already approving the bill. Actually, there was a TWG and they had the chance to already give their opinions there. So
Yes, Madam Chair.
there's a motion.
This is the second.
Second.
Okay, yes. We will listen to you after because the motion is already on the floor. Yes, there's a pending motion. So, there being no objection, the motion is approved. The House bills, the substitute bill is hereby approved, and the corresponding committee report is hereby approved.
Thank you, Madam Chair.
Okay, I'll give you a chance to. Yes.
Thank you, Madam Chair. For Section 8, Digital Nomad Visa Register, the DFA wishes to seek guidance and clarification on the purpose of the creation of the database, specifically for this visa type, and if DFA will be the issuing agency for the visa, for the DFA to maintain the database instead of the Bureau of Immigration.
Madam Chair, can I comment? Yeah, thank you, Madam Chair. I think for the register, I think it's a simple gathering of information of who are those digital nomads coming into the Philippines. So it can be maintained by either the DFA, the Bureau of Immigration, the Department of Tourism, because those agencies are much interested. They're very interested on the people coming in, the visitors coming into our country. So I think there's no problem with that if it can be maintained by more than one agency, Madam Chair.
Thank you po, Congressman Matugas. So I would like to suspend first this part of the meeting so that the resource persons and guests who are not involved in the next items of the agenda can already leave and you are excused. So meeting is suspended. Meeting is resumed. We now proceed to the next item in the agenda. The committee secretary is directed to read the title of the measure.
House Bill number 11043, an act providing for a civil forfeiture in favor of the state, any unlawfully acquired real estate properties by any foreign national, filed by the Honorable Senior Deputy Speaker Aurelio Gonzales, Deputy Speaker David J.J. Suarez, Representatives Robert Ace Barbers, Bienvenido Abante, Dan Fernandez, Joseph Stephen Caraps Paduano, Romeo Acop, Johnny Pimentel, Jervil Jinky Beatrix Luistro, Ramon Rodrigo Gutierrez, Francisco Paulo Ortega, Jefferson Konghun, Jonathan Keith Flores, and Ernesto Junicio Jr. Your Honor.
Thank you, Comsec. The chair recognizes Congresswoman, our Vice Chair, Jinky Luistro, to sponsor the measure.
Thank you, Madam Chair. In representation of the Quad and all the principal authors of House Bill number 11043, I wish to manifest that this is one of the legislative measures which resulted from the inquiry in aid of legislation that was conducted by the Joint Committee on Dangerous Drugs, Human Rights, Public Order, and Public Accounts. In representation of all the principal authors, Madam Chair, please allow me to read the explanatory note which we are adopting as the sponsorship speech. This bill seeks to provide for civil forfeiture in favor of the state any unlawfully acquired real estate properties by any foreign national. The prohibition against land ownership by aliens is undoubted and is primarily found in Article 12, Section 7 and 8 of the 1987 Constitution. It is very clear to all Filipino citizens na ang lupa po dito sa Pilipinas is exclusive for Filipino citizens only, and for corporations, the corporations must be 60% Filipino owned. However, thousands of aliens have been flocking to the Philippines to establish Philippine offshore gaming operators. This has turned out to be closely linked to criminal activities such as human trafficking and illegal drugs. Upon further investigation on POGOs, it was also discovered that these aliens are effectively acquiring Filipino citizenship by securing falsified birth certificates, falsified passports, falsified driver's licenses with the help, I lament, corrupt public officials in the local civil registrars, Department of Foreign Affairs, and the Land Transportation Authority. Using these falsified public documents, these unscrupulous aliens are able to skirt the constitutional prohibition on foreign land ownership. In other words, Madam Chair, esteemed colleagues and resource speakers, marami pong foreign nationals at present time ang nagmamay-ari or nailipat sa kanilang mga pangalan ang lupa ng ating bansa, which are supposed to be exclusive for Filipino nationals as provided under the Philippine Constitution. The continued violation to the provisions of our Constitution on alien land ownership cannot be allowed to continue. More so, that the primary violators belong to the POGO industry, which has already been banned from the Philippines by His Excellency President Ferdinand Marcos Jr. This measure seeks to implement such directive. In fact, the issue of illegal POGOs has already pushed several lawmakers to move for the immediate forfeiture proceedings against said foreign entities and individuals who exploited legal loopholes in the acquisition of Philippine properties. Moving forward, it is then imperative to never let such activities to continue in the Philippines. We need to put an end to this illegal activity of having this alien acquiring the Philippine land. Thus, by reiterating existing policies against foreign land ownership, establishing the necessary communication framework for better enforcement of the prohibition on foreign land ownership, and allocating for public use any real property acquired through successful forfeiture proceedings. The corrupt practices may be curbed, if not totally eliminated. In view of the foregoing, the immediate approval of this bill is highly and earnestly recommended. This explanatory note is signed by SDS Aurelio Don Gonzales, the four chairmen of the Quad, along with the esteemed members of the Quadruple Committee. Thank you, Madam Chair.
Thank you, Vice Chair. We now call on our resource persons to give their comments on the measures. Let's start with the OSG.
Good morning, Your Honors. The OSG has finalized.
Please identify yourself.
Your Honor, I am Associate Solicitor Lance Olives from the OSG. The OSG has already prepared the final draft of the position paper, Your Honors. However, it is still pending approval before Solicitor General Guevara. Your Honor, we shall be submitting the position paper as soon as it is approved by Solicitor General Guevara, Your Honor.
How soon can you submit that?
Your Honors, we shall submit it as soon as possible, Your Honor.
Kung mahirap yun, no? Deadline.
Your Honors, I will refer to my seniors, but within next week, Your Honors, we may submit it.
Okay. Yes, Charan.
Madam Chair, with due respect to the resource persons who are present, in the previous, in many committee hearings before, we have already made a reminder, Madam Chair, to our resource persons to just please submit your position paper in time, or maybe before the committee hearing of any measure to be taken on the floor. Not just to send associate or any authorized representative who will just make a manifestation that their position paper is pending approval. That may not be good for the process we are undertaking here, because you're actually delaying the process that we're supposed to speed up given the time that is allocated to us. And we don't even know if, with due respect to the resource persons who are present, if you are duly authorized to speak for the agency that you are representing. So maybe we should correct that, Madam Chair, because as much as possible, we would need the presence of the head of the agency so that they can explain why they are not coming up with the position paper in time. This is a very crucial piece of legislation, as explained by the author. There should be no delaying here, and the resource person should be as much interested than the author in making your position on the matter so that we can proceed from your position paper and other materials for our deliberation. Thank you, Madam Chair.
I agree with our Vice Chair. Actually, in our invitations, we indicated the head of agency or authorized representative. But that doesn't mean that the authorized representative will come here and just tell us that you will be submitting your position paper. So this is a warning to the resource persons that either the head of agency will be here or you submit the position paper before the hearing. And in fact, the notices were sent very early. So there's no excuse for the delay in the filing or the submission of the position papers. So this is a warning. So next time we won't be as kind. So you please inform your bosses, the head of agency, and maybe next time we can already indicate that the head of agency and not just the authorized representative should be here. Or even if it's an authorized representative, Vice Chair, as long as they can answer the questions. Yes. Not just tell us that the position paper is pending.
Yes. Thank you, Your Honor. We deeply apologize. We are only authorized to manifest that the said position paper has already been submitted. So we shall relay this warning to our
And
peers.
in fact, in the invitation, it already states there that the authorized persons that will be sent should be able to answer the questions of the committee. I mean, everyone is busy. We are all busy, so you are wasting our time. So this is already a warning. Next time, we won't be as kind anymore.
We deeply apologize, Madam Chair.
Yes,
Additional manifestation. So the resource persons will understand where this urgency is coming from. I believe that the Register of Deeds of the province of Pampanga is present in today's hearing. It has come to our knowledge that a number of real properties illegally acquired by foreign nationals have been successfully transferred already to other persons. And what we're trying to do right now is to take hold of these properties and bring it to the benefit of the state in favor of the Filipino people. Kung mabagal po tayo, baka po wala tayong abutin sa mga properties na ito. I understand that the AMLA, Anti-Money Laundering Council, has this authority to initiate the freeze order, but we have to acknowledge the fact that there are certain limitations with respect to the cases when they can file a petition for freeze order. This will help the Philippine government a lot reacquire the real properties which were illegally transferred to foreign nationals so that it will inure to the benefit of the Filipino people. As stated under Section 10, napakaganda na po ng plano kung saan dadalhin ito. And the best illustration for us to better understand what is the intention of this law. Mayroon po tayong mga na-raid na pogo dun sa Pampanga. Right now, the status is uncertain because we do not have sufficient law which will enable the government to reacquire those properties. That includes not only the land, but even the building erected thereon. Dapat po ito pinakikinabangan ng mamamayang Pilipino. Naloko na nga po tayo. Pinakinabangan ng foreign nationals na gamit sa illegal activities. Magbabagal pa po ba tayo? So that at least we can reacquire real properties which should rightfully belong to the Filipino people. Thank you, Madam Chair.
as I mentioned in my opening remarks, the purpose of the deliberations of the bill is to discuss the technical aspects of the bill, so we can already come up with a bill that we will present to the plenary. This is we're not going to discuss factual issues because that has already been exhausted during the Quadcom hearings. So we want to come up with the bill, but how can we do that if the resource persons who are experts, who can help us with the technical aspect of the bill, are not here or are not able to answer the questions or discuss the provisions of the bill? So, warning, next week I intend to have another hearing on this. So you have to be here. The head of agency has to be here, or whoever they send should be able to answer the questions of the committee. Is that clear to all the resource persons? Okay. So we'll now proceed with the AMLA, the Anti-Money Laundering Council.
Yes,
Please
good morning.
identify yourself.
I'm Attorney Anthony Lawrence Morales of the Anti-Money Laundering Council, Madam Chair. Uh, uh, I would like to also apologize for just like in the case of OSG, because as you may know, the Anti-Money Laundering Council is headed by a council which can only act unanimously, and given that that unanimity requirement for the approval of our position paper, we cannot provide for today the formal position paper of the AMLAC, but we can already share the general comments for that we have submitted for the council, Madam Chair.
We continue. I'd like to acknowledge the presence of our another vice chairperson from the Lone District of San Juan, Honorable Isabel Maria Zamora. See, you can proceed.
Yes, Madam Chair. We have just few comments on the draft bill. Our first comment is for the short title, Madam Chair. Maybe it's not that material, but for purposes, Madam Chair, of being specific and to avoid confusion, considering that we have so many civil forfeiture remedies under more prominent laws, Madam Chair, particularly the Anti-Money Laundering Act, the Terrorism Financing Prevention and Suppression Act, the Anti-Terrorism Act, Madam Chair, and even our Ill-Gotten Wealth Act, Madam Chair, all provide for a civil forfeiture remedy. We propose, Madam Chair, that the short title be renamed or be called in other nomenclature. We propose, Madam Chair, titles such as Foreign Acquired Realty Forfeiture Act or Foreign Acquired Land Forfeiture Act instead of a generic Civil Forfeiture Act, Madam Chair.
Can you hold on? Kong Luistro, would you consider would you consider the proposal of the wish?
Can you kindly state the proposed title, short title?
It's either a Foreign Acquired Realty Forfeiture Act, or if we want to be more specific with land, Foreign Acquired Land Forfeiture Act, Madam Chair.
Actually, the purpose of this bill is not to confine the forfeiture to land, but even the properties erected thereon. And as far as we are concerned, everything that is erected on a real property are considered real property as well.
Madam Chair. So in that case, Madam Chair, maybe the committee can consider Foreign Acquired Realty Forfeiture Act. Realty is short for real property, Madam Chair, which is also an accepted nomenclature for real property or real.
Is it not that the meaning is the same? Foreign Acquired Real Property Forfeiture Act.
Yes, Madam Chair. The version of the bill that's what's referred to as states that the short title shall be called Civil Forfeiture Act, Madam Chair.
Short title.
You are referring only to the short title.
Yes, Madam Chair.
Okay, but the long title, just to distinguish, is okay with you.
Yes, Madam Chair.
Foreign Acquired Real Property Act.
Forfeiture Act.
Forfeiture Act. Real Property Forfeiture Act. That is acceptable, Madam Chair.
Thank you, Kong Luistro. You may proceed.
Yes, Madam Chair. For our second comment, Madam Chair, with regard to Section 5, we noticed that the wordings are probably adapted from our law on forfeiture of ill-gotten wealth. So it states that any taxpayer may file a complaint before a city or provincial prosecutor. Although we recognize that the term citizen is already wide enough to cover everyone who can file a complaint before the city or provincial prosecutor, maybe the committee may consider including the term or any taxpayer or government agency, because in most instances we may it's the government agency concerns who will learn about this possible acquisition of foreign land or real estate by foreigners, Madam Chair.
Okay, Kong Jinky.
Madam Chair, I accept the proposition that instead of taxpayer, we use any Filipino citizen.
That would suffice, Madam Chair.
Just to clarify, we do not add any more government agency, Kong Jinky.
I believe, Madam Chair, that when we use any Filipino citizen, that would necessarily include already even the government offices in the Philippines.
That's correct, Madam Chair. Finally, Madam Chair, just for the section 13 of the bill with regard to the issuance of the implementing rules and regulations, we noticed that the proposed provision designates the head of the agency to be the one who will issue the implementing rules and regulations. We just noticed that in most laws where there's a provision for the issuance of implementing rules, it's the agency itself and not the head, for just to give flexibility, Madam Chair. So instead of the Solicitor General shall, in coordination with the secretaries, so it will be the Office of the Solicitor General in coordination with the departments of the identified departments, Madam Chair. And for the anti-money laundering, it should be the Anti-Money Laundering Council as an agency and not the chairman, Madam Chair.
Kong Jinky.
The proposition is accepted, Madam Chair.
Thank you, Madam Chair. That's all, Madam Chair. Subject to the submission of our formal position paper, which will already include what I have manifested, Madam Chair.
Okay, so now we go to the LRA.
Good morning, Madam Chair. My name is Attorney Elizalde, Director for the Legal Service of the agency. First of all, I would like to apologize because we did not bring the position paper. However, it will be submitted later through email if that is acceptable, Madam Chair. And we support the bill, of course, and we only have 2 comments on the matter, which is going to be reflected in our position paper. In section 3, respecting civil forfeiture, it is stated any real estate property transferred or conveyed to unqualified foreign national is null and void. I think this is the provision is muddy. I think our proposition is that it should be stated in this way: any conveyance of title of real estate property to unqualified foreign national, natural or juridical, in violation of the constitutional prohibition is null and void. What we are speaking here is the transaction, the transfer, not the realty itself. So that was overlooked. We just happened to see it yesterday. And secondly, yes,
Can you hold
I'm
on?
sorry.
We'll allow the author to comment on your comment. Yes,
Thank you, Your Honors.
Madam Chair, I acknowledge the point of the resource person and I subscribe to his opinion, Madam Chair.
Maraming salamat po. And there's one more thing. Section 5, it appears that there is no provision on injunction. What we would like the authors to add po is that there is a provision that injunction or a restraining order be issued to the Register of Deeds of the city or province where the land is located, so that they can freeze any transactions which may be made on the property. We would like this because it is the Register of Deeds who has possession of the titles and not the Land Registration Authority, which merely has administrative control over these offices. If it would please the committee, we would like a provision to be included on injunction or a restraining order.
Kong Jinky.
Madam Chair, I wish to bring this to the committee members because I understand that the Register of Deeds are under the Office of the Land Registration Authority. I am more concerned about the bigger perspective rather than pertaining to specific Register of Deeds only. So, may we solicit the opinion of the other committee members? There is no issue about the issuance of TRO, perhaps an injunction later on. However, as to against whom we're going to issue the same, whether it should be the specific register of deeds or the land registration authority itself, in order to encompass all the illegally acquired properties, let us solicit first the opinion of the other committee members.
Thank you, Madam Chair.
Madam Chair,
Thank you.
for the enlightenment of the committee, may we request the register of deeds of or the LRA? How do we distinguish the LRA from RD in as far as the mandate is concerned? It's quite confusing because I believe that the central office is the LRA and all the register of deeds are under the supervision and control of the LRA. That's what I understand.
Who would like to answer that? The LRA?
Yes, Your
go ahead.
Honors.
Please proceed.
The concern here is actually the law, Presidential Decree 1529, or the Property Registration Decree, mandates that the control over title shall be with the registers of deeds and not the LRA. Now, we could receive the injunction at the central office, but we would have to course it down to the registry of deeds. This would be faster in line with Presidential Decree 1529, which gives jurisdiction over the titles upon the registers of deeds. It is a matter of convenience and expeditiousness, Your Honors.
Yes, Kong Acharon.
Madam Chair, are we talking here of a prospective provision on injunction that is going to be enforced against the register of deeds or the LRA? Yeah, I think, Madam Chair, the statement of the representative from the LRA is well. The provisions also of the rules of court in the issuance of injunction, which is actually territorial. So if you impose it against a office which is not within the territory of the property against which the injunction order is going to be implemented, then it's not going to, it's not going to apply really. So I agree that the injunction should be against the register of deeds, which is the actual and final implementing agency as to the issuance of the title. So I agree that the prospective injunctive relief will be against the register of deeds, not the LRA.
Kong Jinky.
Madam Chair, in line with the manifestation of the resource speaker and the Honorable Acharon, and considering the clear provision of PD number 1529, we subscribe to the proposition that the injunction be issued to the RD and not to the LRA. However, Madam Chair, I wish to bring to the attention of the committee as well that apart from the registered properties, there are huge number of properties which are unregistered. And I believe that the Register of Deeds and even the LRA have no control over the same. The one who has control over its issuance and transfer are the provincial assessors, the city and the municipal assessors. So I understand that this bill will still be subject to a lot of revisions, but I wish to manifest the intention of the author to include provincial assessor, city assessor, and municipal assessor every time the LRA and the Register of Deeds are mentioned in this bill, so as to include even the unregistered lands.
Noted. That is noted. Any other comments from the LRA?
The LRA has no more comments.
Thank you. Now we go to the ALG.
Good morning, Madam Chair, and to the members of the esteemed committee.
The Department of the
Please
Interior and Local
introduce
Gov-
yourself first and your.
I am Attorney Ross Bascuña. I'm the Director for Legal and Legislative Liaison, the department, Madam Chair.
Okay, you may proceed.
Thank you, Madam Chair. The Department of the Interior and Local Government fully supports the proposed bill on civil forfeiture of unlawfully acquired real properties by foreign nationals. House Bill 11043 aligns with the principles of good governance, accountability, and national sovereignty, which are fundamental to maintaining the integrity of our country's laws and protecting the interests of the Filipino people. The department recognizes the increasing concerns surrounding the unlawful acquisition of land by foreign nationals, which not only undermines the intent of land ownership laws, but also compromises national security and economic stability. By instituting a legal mechanism for the forfeiture of real properties obtained through legal means, this bill will empower the state to reclaim such properties,
Dalawa na.
ensuring they are returned to rightful ownership and promote fairness within our legal framework. The department is committed to assisting in the effective implementation of this law, including thorough close coordination with relevant local government units, law enforcement agencies, and other stakeholders to ensure that its provisions are upheld and that any illicit activities are addressed appropriately. Thank you, Madam Chair. We will be submitting our finalized and signed position paper within the week, Madam Chair.
Okay, we now proceed to the DOF. Any representative from the DOF? Okay, DAR, representative from the DAR.
Good morning, Your Honors, Madam Chair. I am Attorney Eugene Foliante, the OIC Assistant Secretary for Legal Affairs, Ali Ala, representing the department, Your Honors. May I continue? Yes, Your Honors. Like the others, we don't have yet the finalized comments from the department, but I can verbalize, Your Honors, some of our points in support of the proposed bill. Number 11043, entitled An Act Providing for the Civil Forfeiture in favor of the state, any unlawfully acquired real estate properties by any foreign national, Your Honors. The Department of Agrarian Reform is in full support of this measure. The department is the lead agency in the implementation of the Comprehensive Agrarian Reform Program through land tenure improvement, agrarian justice, and coordinated delivery of essential support, and land tenure improvement, agrarian justice, and coordinated delivery of essential support services to client beneficiaries. Through the effective implementation of the CORP, the DAR seeks to contribute to the attainment of the following goals of the rural development sector, thus agrarian, peace and stability, sustainable development, social justice, and industrialization in the countryside. As the lead agency of the government, tasked to uphold and implement comprehensive and genuine agrarian reform, which actualizes equitable land distribution, ownership, agricultural productivity, and tenure security for, and with the tillers of the land towards the improvement of their quality of life, the intention to forfeit those illegally acquired properties is well within the purview of the program. Your Honors, Section 5 of this measure, proposed measure, giving jurisdiction to the regional trial courts on forfeiture of illegally acquired properties, we would like to impress to this honorable committee that the Office of the Secretary of the Department of Grand Reform has the authority under RA 9700, 6657 as amended by RA 9700. It is now within the jurisdiction of the Office of the Secretary to cancel those issued titles. Considering that a lot of illegally transferred titles involves agricultural lands that were already covered by the Department of Agrarian Reform, and I'm sure 90% of those cases might be those already covered by the Department of Agrarian Reform. In that view, it is now the Office of the Secretary of the DAR that has the authority to cancel. Now, we are proposing, Madam Chair, that the action, jurisdiction, with respect to those for forfeiture of those lands that were already covered by the department should be lodged with the department, Your Honor. Because if we will allow the RTC to process these forfeiture matters, it might transgress the jurisdiction of the Office of the Secretary. And another one, Madam Chair, it will hasten, if it is an administrative forfeiture being done before the Department of Land Reform, it will hasten the processes. And it will, unlike in, I'm sorry for this term, unlike with the regular courts, because of the processes in our regular courts, it has to drag on, Madam Chair. Yes, Madam Chair.
Before you continue, we'll ask Kong Luiso to make a comment.
Madam Chair, I'm lost about the manifestation of the DAR resource speaker, because my understanding is that when the title is DAR issued, the recipient of the title is a Filipino citizen qualified under CARP.
Yes, Madam Chair.
Tama ba?
Yes, Madam Chair.
And I understand that in the titles which are being issued by the DAR, there is a certain prohibition period.
10-year holding period, Madam Chair.
And after 10 years,
They can dispose it.
they can dispose it. Who issues the transfer of the title? Who facilitates the transfer of the title? Is it not at the LRA pa rin?
Yes, Madam Chair.
Yes. So, it is quite confusing that you are manifesting about the transfer of title which is being done by DAR.
Madam Chair, there are illegal transfers being done in the provinces that will, for example, a beneficiary may sell it to a foreigner, may sell it to unqualified owner, no? So it has to be adjudicated before the Office of the DAR. So in that view, those titles that were transferred to those unqualified persons like the foreigners may also be cancelled, Madam Chair.
If the transfer is done within the prohibition period, I believe that whether he is a foreigner or Filipino citizen is not material anymore.
Yes, sir.
Whatever transfer done within the period of 10 years, as you have said, are considered illegal.
Yes,
So I think we're going outside the context of the civil forfeiture, which is the subject matter of this bill. And I wish to submit, Madam Chair, that in as far as illegally acquired by foreign nationals are concerned, the proper agency must be given the mandate to take hold of these properties still is the Register of Deeds in the LRA. and of course the provincial assessors for the unregistered. The authority of the DAR is in line with the implementation of CARP, and I understand that there are illegal transfers in violation of the CARP. However, this is quite outside the context already of the illegally acquired properties by foreign nationals. Nonetheless, I appreciate your manifestation, and I wish to bring to the attention of the LRA and the RD and the assessors that we should focus not only on non-agricultural, but even agricultural, because I understand that most of the illegally transferred really are agricultural properties. And let me take advantage also of this chance to remind the DAR that the office had a very great participation in as far as this anomaly is concerned, because notwithstanding the stringent requirement for the conversion of the property, reclassification of the property, we do not understand really how these foreign nationals were able to facilitate the reclassification, the conversion from agricultural to commercial or industrial in so short a period of time, a period of around 6 months. Alam po natin, napakahirap ng conversion process. And I am anticipating that the Quad will likewise be coming up with a bill that pertains to the land conversion. Siguro kailangan din po nating higpitan. But this time, it's not about the transfer. It's about the mandate about conversion of the land. Madam Chair.
Thank you, Kong Luistro. So, any other comments from?
Yes, we thank you for the comment, Madam Chair. We also support, Madam Chair, Section 10 with respect to the disposal of those forfeited agricultural lands in favor of our agrarian farm beneficiaries. This is well within the mandate of the department. We thank you for including this provision. Section 10, paragraph A, Madam Chair. And our other comments, Madam Chair, shall be forwarded within the week. Actually, it's being drafted. We're so sorry, Madam Chair. We beg the indulgence of the Honorable Committee. It was just referred to me yesterday. Last afternoon yesterday. So I haven't prepared the written comment from the department. Thank you, Madam Chair.
So, I think we've already asked all the resource persons. Are there any other resource persons that we have not called?
Madam Chair,
Yes,
can we solicit just a little comment on the issue that the Honorable Jinky Luistro was discussing with the DAR about just a little, maybe.
enumerate mo ano requirements.
Yeah, may we ask the LRA regarding the issue?
LRA.
Just on the issue that you just discussed with the.
About the land conversion.
Yes,
Pero
yes.
sa DAR yan eh. DAR yun. Kong Ton, I think that's a different committee. Yeah. Agrarian reform.
Not a conversion. By the way, Madam Chair, just a point of discussion, academic discussion. Is there not a conversion thing or matter in the local government unit?
There is reclassification. We call it reclassification.
That's why it's being done. You can do it quick there if you have the you have the numbers.
We need really Congressman Acheron, the Honorable Acheron, to draw the definite line between reclassification, the process we do in the LGU, Sangguniang Bayan, and the land conversion. Because parang nag-overlap ito eh. As you've said, if you have the numbers, land which are supposed to go through the process of conversion, ito nila dinadala sa LGU. to simplify. And we've seen a lot of that in Pampanga in a period of like 3 months, 4 months. One hearing only. And the agricultural land is instantly reclassified into industrial commercial land.
So maybe our members can file the appropriate House resolution so that the appropriate committee can discuss those issues.
Is it not because of the power granted by the local government go to the local government, giving them the power to convert land conversion?
Madam Chair, I understand that the LGU has the authority to do the reclassification. However, it's high time already that we draw the line between the conversion process under the Department of Agrarian Reform and the reclassification, which is under the local government unit, because they are being mixed and mistakenly facilitated as one and the same. Pag ang kaibigan mo nasa DAR, you do the conversion, pero kung wala kang kaibigan doon, and like what Honorable Atcharon said, you have the number in the LGU, what you do is reclassification. No? Let us draw the definite line in between these two processes, including the requirements that we need. Thank you.
Conference Nelly, any other? Are you okay? So before we proceed, I would like to inform the committee that the court administrator submitted a letter that he is precluded from providing a comment on the subject House bill. As such, a statement could potentially preempt any future legal challenges brought before the Supreme Court, particularly on the validity or constitutionality of the aforesaid legislation. Be that as it may, and wanting to preliminarily contribute to the discussion, allow me to submit a copy of AM number 051104, the Supreme Court, dated November 15, 2005, on the rule of procedure in cases of civil forfeiture, asset preservation, and freezing of monetary instrument, property, or proceeds representing, involving, or relating to an unlawful activity or money laundering offense under RA 9160 as amended. Perhaps this will give the committee an initial idea about what the Supreme Court has done so far as civil forfeiture that may, as being contemplated by the proposed measure, specifically apply to foreign nationals. So that is the letter of the court administrator. Maybe we can also consider that their comment. Ong Jinky.
Yes.
Okay. So now that we've heard all the resource persons, what is the pleasure of the committee?
Madam Chair, can I make a
Yes,
I just have a short comment.
yes.
I noticed that some of the provisions here, some of the sections are procedural in nature. For example, we have the filing and venue, and then the next one is contents of the petition, period for answer. And then a few sections later, it's already about the disposal of the property successfully acquired through civil forfeiture proceedings. So for me, it's a little lacking in that we jump from the procedural aspect of the case to disposal without any mention of judgment. I know there's a, here there is the AM 21.3.13 of SC, there's a rule on asset preservation, there's a forfeiture order, but maybe since we already put some sections on procedure here, maybe we can close it by putting a procedure on maybe judgment or decision of the RTC. Just to
Madam Chair, we wish to solicit the legal contribution of the Honorable Zamora. And as far as House Bill number 11043, we are open to adding provisions to this bill and submitting the same in as far as the form and style necessary is concerned.
Thank you.
Thank you,
So
Madam
what is
Chair
the
and Kong
pleasure of the committee?
Motion to suspend.
Yeah.
Madam Chair, I understand that we still have some other matters to be discussed this afternoon. So meantime, I respectfully move that we suspend today's hearing, Mr. Chair, until, Madam Chair, until this afternoon.
Second. Second.
So the meeting is suspended. Thank you, and we will see you at 1 o'clock. Please. Thank you. I would like to recognize Congressman Paulo Ortega to sponsor the measure.
Thank you, Madam Chair. It's an honor to introduce and sponsor House Bill number 10986. And if I may read the explanatory note, this bill seeks to classify and penalize extrajudicial killings as a heinous crime and provide clear legal standards to ensure the accountability for such action. The 1987 Constitution enshrines the state's obligation to value the dignity of every human person and guarantee full respect for human rights. It mandates the protection of life, liberty, and property, and ensures that no person shall be deprived of these fundamental rights without process of law. It is therefore imperative for the state to prevent and address any violation of these rights, including these occurring outside the bounds of the legal system. Extrajudicial killings, or the killing of individuals without judicial proceedings, legal authority, poses a grave threat to the rule of law, democracy, and the protection of human rights. These acts bypass established judicial procedures, undermining public trust in the justice system and violating the basic rights to life and due process guaranteed by the Constitution. The lack of accountability for such crimes contributes to a culture of impunity, where the perpetrators believe they can act without fear of legal consequences. The bill seeks explicitly criminalize EJK, ensuring that any individual, regardless of rank or position, who is found guilty of participating in, authorizing, or condoning such acts will face appropriate criminal penalties. By defining EJK as a specific crime, this bill aims to strengthen the legal framework for investigating, prosecuting, and punishing those responsible for these heinous acts. Furthermore, the proposed measure aligns with the country's international commitments to uphold human rights, particularly under treaties such as the International Covenant on Civil and Political Rights, which requires states to protect the right of life and ensure that no one is arbitrarily deprived of it. The classification of EJK as a heinous crime is a necessary step to restore public confidence in the justice system and uphold the rule of law. It affirms the state's duty to ensure that all individuals are afforded the protection of law and that justice is served in every case of unlawful killing. By adopting this measure, the state not only seeks to provide justice for victims and their families, but also send a clear message to all acts of violence outside the legal processes will not be tolerated. This bill also creates extrajudicial killing claims board, which aims to provide reparations to victims of extrajudicial killings and create mechanisms to address, investigate, and prevent future cases of EJK. According to the report on investigated killings in relation to anti-illegal drug campaign of the Commission on Human Rights, released in 2022, the Commission on Human Rights was able to investigate 846 victims of drug-related extrajudicial killings. 577 were committed by law enforcement officers, and 269 of the unidentified and other types of perpetrators from 2016 to 2022. The reparations provide a small relief to family of the victims of EJK and an acknowledgement of the wrongdoing committed by the state against their loved ones. In view of the foregoing, the immediate passage of this bill is earnestly recommended.
Thank you, Congressman Ortega. Before we begin, there are basic points that I would like to raise, and hopefully after the discussions today, we can answer this issue as to whether there should be two separate bills, one for the definition of the crime and another for the reparations. Because we have to keep in mind that under the Constitution, there should only be one subject in every bill. Every bill passed by Congress shall embrace only one subject which shall be expressed in the title thereof. So that's one thing that's I want to maybe we can decide on that later after we hear all the resource persons. And the other one is the definition of extrajudicial killing. Is it the proper term to use? And these are questions that we can answer after the discussions today. Congressman Manuel, yes.
Madam Chair, thank you. I also would like to share that we in the Makabayan Coalition with colleagues Rep. Franz and Rep. Arlene, we acknowledge the effort of the authors of House Bill 10986 in filing this bill. With the same intention, Madam Chair, we also intend to file our own version of the bill. Hindi lang po naihabol today, but hopefully soon ay ma-file din siya. But its focus would be on recognition and reparation of victims of human rights violations in the past administration. So it is inspired by a similar bill na kumilala po sa mga biktima nung Marcos Senior administration. Pero since limited yung scope nun, yung time frame, so para naman dun sa mga nangyari in the past admin, yun po yung gustong makover nung ating ifa-file na bill. For the record lang din, Madam Chair ng committee. Salamat.
Madam Chair.
Yes,
just
thank
to,
you,
yes,
Commonwealth, and yes.
yeah, Mr. Chair, just to manifest also my observation while we were holding the committee hearings on EJK, dun po sa Committee on Human Rights. Apparently, all of our resource persons agreed that there is no working definition of EJK. We even asked former Senator Laila De Lima, and even some of our resource persons who have been working with the UN, how do we actually understand if there's a legal definition, at least technical definition, a working definition for us to be able to classify whether these killings fall under the scope of an EJK. Unfortunately, sabi nga nila, even in the UN, there's no actual definition of what constitutes EJK. Perhaps the EJK terminologies that were used, some of them said that it was the terms actually were coined by the media, just to define and describe. I guess this bill, Madam Chair, is the authors of this bill is they're trying to now define what EJK, so that our courts would have a legal and working definition in order to set the parameters as well as to maybe perhaps determine the culpability of those who may be charged with EJK. So I just like to put that into context so that we can also move. Maybe that can also be a basis for our discussion, Madam Chair.
At least we have those issues in mind when we discuss the bill. So we shall now proceed with our resource persons. We will listen to the resource person, and then the members can ask questions at any time. Just let me know if you want to make a comment. So first, we'll ask the DOJ. DOJ, please.
Good afternoon, Honorable Chair and members of the committee. For the Department of Justice, first we would like to apologize as our position paper is currently being reviewed by our division head to be submitted to our principal for his approval. But nevertheless, in essence, we interpose no objection as regards the initiative to come up with a bill to penalize EJK, as this is in accordance with Congress's power to give the highest priority to the enactment of measures that protect and enhance the right of the people to human dignity. And further, it is aligned with our international commitments, such as the International Covenant on Civil and Political Rights, and the state has that obligation to harmonize and reflect in its domestic laws the policies behind such a covenant. And also, under the Constitution, it is the state policy to value the dignity of every human person and guarantee full respect for human rights, and that no person shall be deprived of life, liberty, or property without due process of law. And of course, EJK, or the summary or arbitrary killing of an individual, is a grave violation of the most fundamental right, which is the right to life. And it is a threat to our democratic process. Resort to extralegal processes by state agents or those acting with their apparent authority undermines the authority of our courts, who has the sole authority to determine the guilt of a person on whether or not he should be penalized. And of course, resort to these extralegal measures diminishes public trust in our judicial system, and it will promote a culture of impunity. Basically, that is our stand. But nevertheless, after the Secretary have signed that position paper, we will submit it po the soonest. Thank you, ma'am.
DILG.
Good afternoon, Madam Chair, and to the members of the committee. The DILG has already submitted its position paper via email to the committee secretariat, Madam Chair. But allow me to read the salient portions of our position paper and also a few of our comments. We respectfully manifest the Department's unwavering support for House Bill number 10986 and its objectives of defining, penalizing, and preventing extrajudicial killings in the Philippines. The Department believes that this legislative measure will enhance the country's commitment to justice, human rights, and the rule of law. To strengthen the bill and ensure its effective implementation, the DILG offers the following recommendations or clarifications. Number 1, on preventive suspension, we propose that parameters be included, particularly in Section 10. Will it be the parameters on the imposition of preventive suspension as mentioned under the local government code, or it will be the parameters mentioned under the rules of the Office of the Ombudsman, Madam Chair? For clarity, Madam Chair, under the local government code, it states therein that preventive suspension may be imposed at any time after the issues are joined, when the evidence of guilt is strong, and given the gravity of the offense, there is great probability that the continuance in the office of the respondent could influence the witnesses or pose a threat to the safety and integrity of the records and other evidence. While under Administrative Order number 17 of the Office of the Ombudsman, Your Honor, Madam Chair, it states that under Section 9, pending investigation, the respondent may be preventively suspended without pay if, in the judgment of the Ombudsman or his proper deputy, the evidence of guilt is strong and the charge against such officer or employee involves dishonesty, oppression, or gross misconduct or gross neglect in the performance of duty.
Yeah, which standard do you want to use for this section?
If I don't know with the rest of my colleagues and co-authors, but I am more inclined to the ombudsman's because that in a way would insulate any possible intervention from the ones that has been charged with a case, no, of AJK, Madam Chair. But again, I subscribe to the collective wisdom of this committee. That is just my personal take on that.
Any comments from, yes,
May I just ask is it the ILG?
Yes, Madam
Yeah,
Chair.
who said earlier that we will try to improve the provision on preventive suspension. May I know if that is, that is your position, original position, that preventive suspension is or can be part of this provision of this law and this measure being on the table? Because remember, Madam Chair, a preventive suspension is more appropriately or commonly used in administrative or even employment context. That is to ensure that the one facing charges do not interfere or does not interfere with the evidence or does not influence the witnesses. So do you still see the relevance of this in a penal law? Because we are legislating a penal measure. And then, so as I said, para po yata ito sa administrative regulation.
Yes, Kong. See.
We can also make some hybrid, no? It's a combination of the two. I agree with Representative Acharon. It's about it's only about the administrative cases that's been filed. But if you can actually do some combination of the two naman I mean, if there's no violations under the Constitution, maybe we can also explore on probably introducing the combination of the two.
That is why, Madam Chair,
aspect.
we are soliciting the insight of the DILG because DILG is more concentrated or focused on measures relating to administrative matter. Because I believe that this is something really administrative, not in nature, not a penalty that applies to administrative offices or administrative disciplinary action.
Madam Chair, the DLG interposes no objection on the inclusion of a provision on preventive suspension on the bill. However, our concern is only that it should be streamlined with our current parameters, with the existing parameters on preventive suspension, Your Honor. And also, Your Honor, I observed that under Section 10, the provision on preventive suspension is limited to, if I may read, Madam Chair, if the charges against such officer involve in action to prevent the commission of extrajudicial killing. So in essence, Madam Chair, this provision is limited to administrative cases and it does not cover criminal cases, Madam Chair.
I don't know if DOJ can also give us their insight, no? But I'd like to ask, if for example we introduced in the bill probably combination of the two, some aspect on the penal, in relation to preventive suspension, and as well as to also get some portion of the yung ombudsman. What would be the position of DOJ and DILG on this? Since we are trying to explore, Madam Chair, the possibility perhaps of combining the two, since extrajudicial killing, though it is loosely used, but it has never been defined based on its legal parameters, no? So on that note, Madam Chair, I may also ask, what would be the position of the DILG and DOJ on this matter?
For the department, Honorable Ma'am and Sir, with regard to the inclusion of that provision for preventive suspension, first we have to see that if the offender is a public officer, and this preventive suspension pertains to the administrative aspect, we have that threefold liability rule po kasi for public officers. If ever he commit an offense, he or she may be held criminally, administratively, and civilly liable. So, for our part, we subject to further improvements naman po as regards the preventive suspension. So we support such inclusion naman.
Yes, Madam Chair. I believe, Madam Chair, that the Ombudsman has no jurisdiction over the commission of this crime because this is not related in the performance of your duties. Only public officers in the performance of their duties can be tried before the office of the Ombudsman. But in this case, extrajudicial killing is not related in the performance of the duties of the public officer. Madam.
The ILG.
Madam Chair, I agree with the sentiment of Honorable Fresnedi. However, Madam Chair, the bill also has provisions on administrative negligence committed by public officers in charge of public order and safety and also the local chief executives, Madam Chair. So in that regard, Madam Chair, it is my position that the provision on administrative negligence may be covered by the jurisdiction of the Ombudsman, Madam Chair.
Maybe that will be subject to further discussion. Okay. Let's hear the rest of your comments first and then.
And second, Madam Chair, the department also has a comment on the period of preventive suspension, which is under Section 10 is for a period of 120 days. However, Your Honor, we also need to streamline this with the Ombudsman rules, which states that the respondent may be put under preventive suspension for a maximum period of 6 months, while under the local government code, it is 60 days, Madam Chair.
Just to clarify, attorney, yung raise mo na issue is not whether who has jurisdiction, ombudsman, or hindi
Yes,
yun na
Madam
issue.
Chair.
Yung inaano mo yung parameters.
Yes, Madam Chair.
Which ones do you follow yung sa rules na ombudsman or sa local government code? Tama ba yung...
Yes, Madam Chair. Just to avoid any future issues, Madam Chair, because, for instance, Madam Chair, a case is taken cognizance of by the Office of the Ombudsman with the provision that the maximum period for preventive suspension under this bill is 120 days only. There might be an issue with the Office of the Ombudsman, as it might be of the position that their authority to regulate, to enforce rules and regulations is being encroached upon by this bill, Madam Chair.
Kong Zia, you have any comments? Kong Adjun, you have any comments? Maybe we can also invite them next time to shed light on this. Yeah.
Yeah, I agree. Tama po yung yung tanong. Yeah, tama po yung sabi. What you're proposing, you're giving us an option whether or not to apply yung administrative sanction as to the preventive suspension ng ombudsman and yung sa penalty. Again, Madam Chair, I don't know because I'm just trying to also solicit the ideas of our resource person. Ang aking position, Madam Chair, is since we are, sabi nga niya yung sa Section 9 and Section 10, he mentioned about Section 9 and Section 10, there's a presumption of administrative negligence. So maybe on the case of that particular subsection, Madam Chair, I don't know, I'm just thinking outside of the box. Maybe we can apply preventive suspension administratively because since we already have that parameters, and in the case of the criminal liability, then we can also adopt. Should we decide on avoiding any legal problems in the future, then we can also separate the two. That is my position on that. If we are to really be more conservative about avoiding any possible legal conflicts that may arise once we decide on passing this, approving this law. Or we can do some combination. I don't know. I'm just trying to explore, Madam Chair, because this is the first time that this country is proposing this kind of measure. which talks about extrajudicial. I believe what the good DILG representative is pointing out to this committee are laws or policies that have been adopted prior to the issue on EJK. And that is why these policies, these laws that he mentioned, are not receptive to the possible scenario that might happen, especially EJK. So I don't know, that is my take on that.
Madam Chair, may we hear from other resource persons so that they may enlighten us regarding this subject matter, Madam Chair?
Madam Chair, I also subscribe to the suggestion of the Honorable Presnedi. Anyway, we would like to encourage our resource persons to say what is really their feeling about the legislation. This is not an investigation in aid of legislation, whether it's a contempt. These two here present will for sure does not have the propensity to detain anyone in the resource persons. So please say your piece, and your lips will not be sealed, and you will not be detained, so that we can come up with the more improved and refined version of our law. Thank you, Madam Chair.
Actually, an academic discussion.
Yes.
Yes. So if there's anyone who, maybe when it's your turn, DILG, do you have anything else to say so that we can listen to the other?
Just one last comment, Madam
Yeah,
Chair.
but we'll let him finish so that we can go ahead.
On the it is about Section 5, Madam Chair, on monetary reparation for victims. We noticed that there's no provision or statement as to where the funds will be sourced.
Will be
Sourced. And also as to the salaries and emoluments of the members of the extrajudicial claims board, Madam Chair.
I think that is in Section 13. No, I mean the appropriations.
Appropriation.
Yung source nasa Section 13.
I stand corrected, Madam Chair.
Yun lang.
Yes, Madam Chair.
Okay. Okay. So next OSG, tama-tama they were raising. One of them was raising, you were raising your hand.
Good afternoon, Madam Chair, members of the committee, and everyone in attendance. I am State Solicitor Juan Roselyn Europa. The Office of the Solicitor General already submitted our position paper last December 3 on the bill under consideration, but I would like to discuss some of our comments. We have comments and recommendations on several sections of the bill under consideration, but let me go first, Madam Chair, to the 2 points that you mentioned earlier. One is the issue on the one title, one subject requirement of the Constitution. That was one of the issues that was deliberated upon by those who crafted our position paper for the OSG, and we stated in our position paper that in our opinion the provisions of the proposed bill are germane to the objectives of the bill as stated in its declaration of policy. However, just to be sure that it won't be subjected to a collateral attack, we suggested that perhaps the bill, the title of the bill could be amended or revised to read instead an act to address and sorry, what was that again? An act to address. An act to address and prevent extrajudicial killings, just so it will be a more comprehensive title. And we also cited in our position paper Farinas versus Executive Secretary, where it states that, if I may read, in Farinas versus Executive Secretary, it states that the title is sufficient if it be comprehensive enough, reasonably to include the general object which a statute seeks to effect, without expressing each and every end and means necessary or convenient for the accomplishing of that object. So in our opinion, Madam Chair, if it's a question of whether we should split the bill into two, one for, defining EJK and making it a heinous crime, and one for making a reparations board or committee for it. We believe that if the title were to be stated as an act to address and prevent extrajudicial killings, we feel like perhaps it could cover the reparations portion of the bill. That is the opinion of the Office of the Solicitor General. And as to the second point, Madam Chair, that you mentioned earlier, with respect to the definition of extrajudicial killing, we have here in our position paper a recommendation on how the definition in the proposed bill could be reworded. Also, we pointed out that there is a definition of extrajudicial killing in RA 11088, was it? 11188. But although that is regarding special, in armed conflict, children in armed conflict, so it's not really, perhaps that definition,
Look at it, yeah.
but perhaps that definition is too vague for our purposes here in the bill under consideration. But that's one thing that in our suggested rewording, that's the definition in that act is something that we try to incorporate just so there could be a more comprehensive, perhaps, working definition of what an extrajudicial killing is. And then, as regards our other comments, Madam Chair, should I go through all our comments in the position paper?
But first of all, Madam Chair, I didn't know there was already a definition supplied. Which, ano po yung, pwede pong paano yun? Ano pong batas yun?
Yes, Your Honor. It's entitled the Special Protection of Children in Situations of Armed Conflict Act.
Okay.
Although we admit that it's not, it's not.
But have you included that in your position paper?
Yes, po.
Okay.
Yes, po. Sorry, go ahead.
Yes, I'd like to ask po, go back to the yung title po. Ma'am, have you read the title po na kasi parang sinasabi din po dito just to get your yung para ma-explain mo further yung so you want to make it as simple as possible, the title, no? Kasi parang nandito rin po sa title nito on the last phrase, no, strengthening the mechanism for its prevention. Would you like to, are you proposing that to make it shorter and more simple para hindi siya masyadong matouch yung issue ng two subject matters, yung overriding na mga...
Your Honor, that is the suggestion of our office, maybe a more broad, comprehensive title. Anyway, since in the declaration of policy, it will be stated there, that
so would it be kung halimbawa can you state your proposed title kung po pwede?
It is in the particular paper, but I also read it. I will just we recommend that it be entitled An Act to Address and Prevent Extrajudicial Killing.
Period. Thank you, Madam Chair. Can you, mayroon ka pang other points to raise?
I think, Your Honor, just one last, because this is one of the most important comments that we have in our position paper. We suggested, if I may read, to further strengthen the proposed law and underscore the government's commitment to addressing extrajudicial killings, it is recommended to include a provision penalizing states agents' negligence in investigating such cases. So we included here in our position paper a sample draft provision, a malicious inaction in investigating EJ case. That is on the last page of our position paper po.
May we know, Madam Chair, if the OSG is supportive of this bill? Just want to be categorically.
Yes, of course.
Okay,
of
thank
course.
you.
It goes without saying, but
I
yes,
think
Your
they
Honor.
they submitted the position paper, and then they gave comments for each provision, and then they gave their recommendations, if any. So I think we can use their position paper. Anything else from the members?
Madam Chair, may I ask the Office of the Solicitor General whether, in fact, the term extrajudicial killing is something that is acceptable to your office as a term that we would be using for purposes of this proposed measure?
Not just the definition, but the term itself.
Yes, yes.
OSG. Yeah,
Yes, yes, Your Honors. We are actually using extrajudicial killings in our pleadings. And it is also in the decisions of the courts, Your Honors.
But I'd like to know, Madam Chair, if there is a specific provision of law at present that deals with extrajudicial killing.
There is none, Your Honor. So far, there is none.
this is the
Yeah,
one
this-
on flashed on the
Yeah.
That's the one.
RA 1188.
Yeah. Madam Chair, I just want to be correct. I just want to correct myself. Early, I said probably the terminologies were coined by the media. I would like to stand corrected on that. I did not know that they've been using this this phrase in legal in the courts, and there's already a law that defines extrajudicial killing. Just to put on record, Madam Chair. Thank you.
It's noted and
Madam Chair, actually I asked that because if you try to read the proposed measure, in section 3, definition of terms, paragraph A, it says, extrajudicial killing refers to any killing other than that imposed by the state. So I wondered if there is a killing which is imposed by the state. I'm confused with that. So in other words, this killing other than extrajudicial that is imposed by the state what is your take on this?
yes.
Your Honor.
Go ahead. Oh, wala.
From what we have, from our idea, or from what we have gathered from the court decisions, extrajudicial killings, these are acts committed by public officers without they are not really or actually authorized by the state, but they are committed by public officers. So extrajudicial killings are committed by, it cannot be called extrajudicial killings if it is not committed by public officers.
Madam Chair, what is your take on this definition that extrajudicial killing refers to any killing other than that imposed by the state? Is that going to appear, or suppose now that there are other killings which are imposed by the state? There is none.
It is not sanctioned by the state, Your Honor. It is not sanctioned by the state.
Just to answer, Congressman, your question. In our position paper, actually, that is one of the things that we pointed out, that the definition, referral to the killing other than that imposed by the state, it causes some confusion because, again, as stated in our position, there is supposedly there should be no death penalty, so there should be no killing pursuant imposed by the state. So that's one, actually, yes, that's exactly one of the things that we pointed out in our position paper.
Madam Chair.
Yes, Madam Chair. I just would like to react to the statement of the representative from OSG. that all actors must be a public officers. I don't believe, Madam Chair, that all the perpetrators of this killing must always be public officers, because there are those who are hired by the public officers, but they are not. They are not public officers. So I believe this is a government-sanctioned illegal killings, but not necessarily all actors are public officers, Madam Chair.
Sir, may I just clarify?
Can you wait?
Sorry.
Kung easy, you wanted to say something.
Oh, okay. I think we have, all of us have a basic understanding of what an EJK is. I mean, there's a widely accepted definition, maybe imposed to us by media, but I think the definition under Section 3A should be revised, just because I agree with the OSG. Section 3A seems to tell us that there are state-sanctioned killings, and there will never be a time from now on that there will be state-sanctioned killings, as we already signed, if I'm not mistaken. Is that a treaty or something that we are bound not to reintroduce death penalty? So having said that, there will be no killing imposed by the state or any deliberate and arbitrary killing of any person not under a previous judgment. That's why I think we have to reword Section 3A.
Okay, now you can speak. Please wait to be acknowledged. Yes.
Apologies, Madam Chair. I just would like to clarify, Your Honor, what you mentioned a while ago, that there are perpetrators who are not public officers, but under Section 4 of the proposed bill, they are acting under the actual or apparent authority of the public officers. So, technically, it is the responsibility or also the liability of the public officer. That is my opinion.
But Madam Chair, the earlier statement was that all perpetrators must be government employees or officials. But there are those perpetrators who are hired by the government officials or employees to do this extrajudicial killing, Madam Chair. That is my only point, Madam Chair.
So in effect, the provision on preventive suspension only applies to public officers.
Not necessarily, Madam Chair. This is a government-sanctioned extrajudicial killing or commission of crime. Government sanctioned, but not necessarily all perpetrators are government employees or officials.
Madam Chair, may I pose a question to OSG? Perhaps we can enlighten. Gusto ko lang po yung text, yung sinabi po ni Manong Jaime. This is what we're trying to propose here is a bill, and hopefully it will become a law. And terms and words that are used, the language in itself should be very, very specific, because I believe that's how courts can really decide on. Because though we may loosely use the word extrajudicial killings, but in application as to the hearing this in the courts, they are supposed to be definitive and some legal implications. May I also, kasi yung sinabi po ni Manong Jaime, OSG, I just also want to be clarified, how can you delineate, for example, in terms of the legal implication vis-a-vis the culpability and the penalty ascribed to commissioning of certain acts of a crime? How can we be clarified paano mo masasabi na it's an extrajudicial killing and paano mo masasabi na it's a murder? Because I guess there's a very thin line, a hair-splitting difference between these two if you look at it, no? Kasi nag-gets ko po yung ano ni Manong Jaime, though they are not public officers but they have been commissioned by allegedly by a public officer to commit this crime on their behalf. So gusto ko lang po malaman, can you also maybe provide us so that we can refine this bill? Because I believe there's already a penalty for murder, right? It's under the heinous crime. Although it may fall within the ambit of, you know, that specific action or a specific crime, but it's, sabi ko nga, it's a hair splitting yung difference ng two. Can you, yes, please, OSG.
Sir, you are asking for the difference between murder and extrajudicial killing.
Here is that of the, yes.
Sir, before that po, we have a, our position paper, in our position paper, the OSG has a recommendation for the rewording of Section 3A, actually po. Because since we opine that the wording of Section 3A may cause confusion in the proposed
3A?
Yes, sir.
3A.
The OSG suggested a rewording of the of said provision. May I read the suggested rewording?
Yes.
Extrajudicial killing. Okay. I'll read first the proposed provision in the bill. Extrajudicial killing refers to any killing other than that imposed by the state pursuant to the provisions of the Constitution on heinous crimes, or a deliberate and arbitrary killing of any person not authorized by a previous judgment pronounced by a competent court, affording all the judicial guarantees which are recognized as indispensable by civilized peoples. It may be committed by a public officer, person in authority, agent of a person in authority, or any person who is acting under the actual or apparent authority of the state. So since it is our opinion that the wording of Section 3A may cause confusion because as a signatory to the second optional protocol to the International Covenant on Civil and Political Rights, the Philippines is legally bound not to reintroduce the death penalty as a capital punishment. Thus, the definition should focus on deliberate and unlawful killings without due process of law, instead of making it appear that the Philippines allows killings sanctioned by the state and all the courts of competent jurisdiction. So the rewording reads as follows. Extrajudicial killing refers to the deliberate and unlawful killing of any person for any purpose by a public officer, person in authority, agent of a person in authority, or any person who is acting under the actual or apparent authority of the state. The killing is without a lawful court order, meaning it is not, since there is no death penalty. If there is a death penalty, if the death penalty will be lifted, then the court may order the killing, because that's what we were referring with the phrase "the killing is without a lawful court order" or due process as guaranteed under the Constitution and recognized international human rights standards. Such killings violate the general recognition of the right to life as embodied under the Universal Declaration of Human Rights, the United Nations Covenant on Civil and Political Rights, the United Nations Conventions on the Rights of the Child, and the similar other human rights treaties to which the Philippines is a state party.
We'll flash the suggested.
Madam Chair.
Yes,
may we also recognize the lady
Before we continue, I'd like to acknowledge the presence of one of the authors of the bill, Congressman Bienvenido Abante from the 6th District of Manila.
Thank you, Madam Chair. Sorry for being late.
Thank you.
Okay.
Okay, so while we're waiting for the technical issues here to be resolved. Can we hear from the...
Yeah, I say something for a
Yes,
while.
sir.
I've been watching the deliberation in my car coming here. And the definition given by the OSG is very good, no? But we would like this to be simplified. All right? Napakahaba eh. If you could be able to simplify the definition, we do not even need to mention the United Nations, whatever it might be, you know. Hindi niya kailangan yun eh. If we should simplify it, you mentioned about us being a part of the United Nations, as far as taking away the capital punishment is or death penalty, no? Nilagay lamang namin dito yung tinatawag nating penalty of life imprisonment because we do not have yet the death penalty. But we are also going to file a bill reimposing the death penalty. And we do not even care about what the United Nations tells us because we are a sovereign country. So we will be filing that. So therefore, kami mamaya, we're going to change that. Siguro pag in-approve na yung death penalty because we need the death penalty now. Nakita natin yung extrajudicial killings. We need that now instead of people like what we're saying now, killing people, di ba, against the Constitution, i-institute natin yung death penalty. Mas maganda yung ganun. Di ba?
Going back to the definition proposed by...
Short.
Yes, go ahead.
Yeah. Madam Chair, please po so far sa dinadali din ng discussion natin, I also believe that we have to revise the definition so far na nasa House Bill 10986. Although sa pagtingin natin, Madam Chair, ng representation na ito, with all due respect sa colleague po natin, I think mas may na po na ma-phrase yung definition ang hindi po nakadepend dun sa posibleng anumang pre-imposition ng death penalty since also that would entail further discussion pa among members of the House. Sin lang, Madam Chair. Thank you.
Anyway, this is just a suggestion of the OSG, so it will be up to the committee to refine it. I mean, we don't have to adopt it word for word, no. But at least they are just suggesting. So this is their suggestion that's on the screen, which is more general, I guess. But yun nga, medyo mahaba, so we can also refine that.
Ano, Madam Chair, do we submit na to us naman, di ba?
Yes, yes. They already submitted this last, December, kailan niyo sinubmit? Yeah, they submitted early. Yes, you have something to say.
Your Honor, Madam Chair, just wanted to go back to the question po of Congressman Adyong. He asked earlier, if it's a fine line, if we're gonna split hairs between what is murder and what is an extrajudicial
that
killing.
was the question.
Yeah. In my opinion, that's a very good question. But right now, I'm gonna speak in terms of my personal opinion. This is not in the position paper anymore. I feel like if a person, let's say, not a state agent, any person, but someone who kills someone under an apparent or authority given by a public official, this is again my personal opinion, that should be considered an extrajudicial killing as opposed to murder, because murder, for example, I can murder someone because I'm mad at that person or for any other reason other than being na parang inutusan ako, binayaran ako ng public officer. For me, that's as long as, let's say, a certain killing, it fits the requisites of what murder is under the law, that's murder. But for extrajudicial killing, parang kumbaga po, let's add another requisite that it was done because it was ordered by or apparent or actual, under the apparent or actual authority of a public official. Parang ganun po. But that's my personal opinion.
Okay. Any other resource person who would like to
Madam Chair, let me...
Yes, Kong Abante.
Okay yung opinion mo eh. No? And that is the reason why we filed this bill, because all of the policemen that killed supposedly the victims were charged in court as homicide, not murder. In reality, that is murder. Di ba? Ang kanilang katuwiran lang, kaya homicide yan, nanlaban. Kaya nga sinasabi namin, I think we should even have an ocular inspection in the crime lab of the Philippine National Police, sapagkat if they killed more than 7,000 of the victims, nanlaban lahat yan, there ought to be an evidence. Di ba? Ng weapons, whatever weapons it might be, sa nanlaban. Kung wala, that would be murder. Therefore, kaya namin nanunod itong bill na itong extrajudicial killings.
For this send to the OSG, no? And whoever, yung mga resource persons natin, would it be an option to make it a qualifying circumstance so that that will be murder instead of a separate offense? Well, is that something that we should consider?
Madam Chair, you mean a qualifying circumstance to make it an EJK instead?
Yes.
Instead of just murder?
Instead of having another bill na magiging murder, siya yung sinasabi ni Kong Abante. Kasi nga homicide lang ngayon ang fina-file sa kanila.
Your Honor,
talagang kailangan special,
Madam Chair,
separate bill.
But
yes, go ahead.
Madam Chair, I don't think that it is only homicide that was being filed for cases of killing, like in the case of Kian de los Santos. Murder, the charge was murder. May conviction na po yun.
Conviction na yun.
Opo.
Because, Madam Chair,
Yes, Kong Abante.
because in the first place, there was no weapon found kay Kian de los Santos. In reality, that's why it's murder. Pero karamihan, for example, like in Caloocan, the first charge against the policeman who killed those victims was murder. But then it was changed by the ombudsman to homicide. Why? Sapagkat nanlaban daw yung mga tao. So, but then the evidence would be, nasaan yung evidence na nanlaban sila? That is actually the question. Oo. Kaya, because, kaya Madam Chair, nagkaroon ng ganitong bill, no? To be able to perhaps make a definite definition ng extrajudicial killings.
So I think there is a distinction naman po. May difference naman po, like what Attorney Europas discussed a while ago. Meron naman pong there's thin line between murder and extrajudicial killing. So dun po sa mga previous cases, since we don't have an extrajudicial killing law yet, so ganun po, they are treated as regular crime under the revised penal code. So kung walang qualifying circumstances po, homicide siya. And then murder pag may qualifying po.
Madam Chair, yes, I think on the issue of whether or not an officer commits a extrajudicial killing, mas madali po yung ma-identify because pag officer talaga in the line of duty, for example, makikita mo naman talaga, no? What is more difficult, I guess, for this committee is to at least contextualize or to describe the manner by which a contracting assassin. Yun lang mahirap maybe we can also ask OSG to help us out on how to determine. Kasi halimbawa, meron akong na-contact na na tatlo para patayin si ito, si ito, si ito. No joke, no joke. Yung mga ganong klaseng senaryo, yun ang mahirap i-prove. So maybe we can ask OSG to at least help us out to describe in that kind of scenario and circumstance.
Before we continue, I'd like to acknowledge the presence of Deputy Minority Leader Franz Castro. OSG? OSG yung question mo? It's for OSG, Kong Zia? For OSG.
I'd like to maybe solicit the opinion and then maybe perhaps an advice, maybe input from the OSG, because I think that's where the problem, and I think that's the difficulty. Kasi nandito po sa Section 9 and sa Section 10, di ba? Yung kaya nga tayo nagkakaroon ng preventive, yung presumption yung negligence nung part nung kasi officer, kasi nag-contract siya ng isang assassin or isang hired gun, yung mga vigilante na type of killings. Doon mo tayo magkakaproblema doon. Yung nagko-contract ka ng isang services ng hired killers. So I guess yung naka-fall doon po sa definition ng EJK, di ba? It's not a murder because sabi nga ng lady lawyer natin, if it's a murder, I have a grudge against a particular person, then ginawa ko yun. But this one is yung commission ng crime is wala kang pakialam, wala kayong connection doon sa taong yun, basta lang kasi kinuha ka, kinontract yung services mo, then ginawa mo yun. That falls under EJK kasi public officer yung nakipag-usap sa'yo. I don't know, for political reason, whatever. No? So gusto ko lang pong, I think, makunan ko ano yung possible na po pwedeng may dagdag ng OSG on that circumstance to define that particular circumstance so that we can have a very clear qualifier na yung sinasabi po na scenario where we can connect this particular officer and those of individuals who have been hired to kill a certain individual that would fall under the category of EJK. Doon po ako magkakaroon ng problema, I guess, Madam Chair.
Madam Chair, perhaps we can go back to the explanatory note now, where we said that extrajudicial killing or the killing of individuals without judicial proceedings or legal authority poses a great threat to the rule of law, democracy, and the protection of human rights. These acts bypass established judicial procedures, undermining public trust in the justice system, and violating the basic rights to life and due process guaranteed by the Constitution. The lack of accountability for such crimes contributes to a culture of impunity where perpetrators believe they can act without fear or legal consequences. Yun po yung nakalagay namin sa explanatory note. Perhaps our OSG, who are really very good lawyers, could read the explanatory note first and then make suggestions as far as simplifying some provisions in the bill. Madam Chair.
Yes, OSG.
That is noted, Your Honor.
And I would like to ask Kong Samora if her question was answered.
Yes, Madam Chair. I think actually I was just showing my support to the OSG's position. And Madam Chair, I also want to manifest that I agree actually with your suggestion earlier about maybe making the circumstances present in the killing an aggravating circumstance. I went through the many circumstances which aggravate criminal liability. And maybe just a suggestion, maybe we could add the circumstances of EJK to this. It would make murder or homicide murder under the circumstances, the aggravating circumstances of EJK. After all, murder is punishable by reclusion perpetua, and here the penalty that they want to impose, I believe, is life imprisonment. which is actually properly termed as reclusion perpetua under our RPC. So, there,
OSG,
Madam Chair.
any comments on the... Any comments, OSG? Yes?
Your Honor, just to go back po dun sa question again ni Congressman Adyong regarding, yun nga po, the difficulty in his question. Wait. Again, we were brainstorming here, but again, this is not in our position paper. We admit na mahirap po kasi to prove it, diba? When is it murder, when is it EJK? But yun nga, if you're contracted, if a person killed someone because he was contracted by a public official, it's a matter of evidence, it's a matter of defense. So I was just thinking lang at the top of my head, could it be possible that perhaps the prosecutor files a murder charge, and then during preliminary investigation or proceedings before the prosecutor, the person complained of na who killed somebody, na EJK, he could raise that as a defense na he was contracted by someone, and then after he raises that as a defense, I'm not sure we can amend the information to make it an EJK. Parang ganun po siguro.
Your thoughts? Well, before that, can you answer first the question of Congresswoman Samor?
Sorry, Congressman Bell. What was the question again?
I was actually showing my support to the suggestion of Chair about making the circumstances present in an EJK killing an aggravating circumstance. Or, yes.
An aggravating circumstance to
if it's homicide, then it becomes, make it murder, something like that.
Yes, Kong.
Madam Chair, may I ask therefore the OSG, no? Upon reading the bill, how do you differentiate between EJK and murder?
Sir, yun nga po, as mentioned a while ago, when it's murder, regular killing po siya. Pero pag meron ng order from a public officer, sanction siya ng kung sino man yung public official, then it becomes extrajudicial killing.
Yes, Kong Samor.
Madam Chair, actually one more thing that we were looking into. Under Section 4, it says here, extrajudicial killing committed by a public officer, person, authority, agent of a person in authority, or any person who is acting under the actual or apparent authority of the state. What I was discussing with Kong Ton earlier was that, is there actually an actual authority from the state to commit extrajudicial killing? Maybe there can be an apparent authority from authority of the state, but I have issues with it being an actual authority of the state to commit extrajudicial killing. So I think that that goes together with our earlier discussion.
Madam Chair.
Yes.
I think we should first issue or settle the issue as to whether there is a difference really between murder and extrajudicial killing, because going back to the question or suggestion of the Honorable Chair, if we can make extrajudicial as a mode of killing, as an aggravating circumstance to make it murder, then it's going to have the same effect, because the penalty will be reclusion perpetua, there being no death sentences at this time, no? So, did it occur to you, your office, whether personal or official opinion, that there's no need to make extrajudicial killing as a separate act, but just instead make it an aggravating circumstance, so that it can be part of the aggravating circumstances already listed in the revised penal code?
Wait, I just want to clarify, it wasn't a suggestion, Kong Ton. It was a question. I was asking a question. I was asking a question to the OSG earlier. Yes, OSG.
I see. Sige, go ahead.
The intent. Yung intent. Wait. Let's answer one by one. Madam Chair, regarding the suggestion on whether we can just make it an aggravating circumstance, an addition to the aggravating circumstances to qualify it to murder, our concern with that would be, well, one, if we just make it murder, then we won't have this reparation for victims or EJKs anymore. That's our number at the top of our head. That's our concern. There will be no reparations for victims of EJKs anymore. But my colleague, Attorney Ellie, she has a no. You have a good. She has a good idea. Let's all on this together. Good afternoon, Your Honors. Regarding the issue as to defining the line between murder and EJK, my own personal position on that is the intent would be the defining line. Because with murder, you have the intention is to kill someone. There's a personal grudge. There's a specific intention. As opposed to EJK, where the killing is how do I say it? Kind of a collateral effect of what a public officer wants to happen. So it's they don't the killing is not directed on a specific person. It's unrestrained killings because of a certain goal that needs to be achieved by a certain public officer or a state agent using a color of apparent authority.
Madam Chair.
Yes, sir.
Nagustuhan ko yan, unrestrained killing. Ganito yan eh. I don't know kung nanonood kayo ng aming Qualcomm hearing. No? Mukhang hindi. Anyway, kaya namin nag-ask yung bill na to. Ganito yan eh. Okay, I asked the former president. Sabi ko sa kanya, because he was actually putting the blame on the policeman that killed it. They should know the law. Yun ang sabi niya eh. No? Ako lang ang nabigay ng policy. So I told the former president, you are a prosecutor at one time. You made a policy, a presidential policy. It's not based on the Constitution. It was only based upon his own personal policy. Ngayon, nung siya nabigay ng ganyang policy, na-involve din yung mga police. Right, to kill. Without even thinking of what the Constitution says. Oo, yun ang unrestrained killing. Maganda yung sinabi niyo, Madam Chair. So may I suggest that we create a TWG, Madam Chair, that would include the OSG, to finally make a study on this so that we could be able to tackle the bill in a most, in a better way, no? Kung may TWG tayo, pag-usapan nyo na muna lahat yan, and then ibalik nyo sa amin lahat ng mga recommendations nyo, and then we could be able to tackle it in a more intelligent way, intelligent way. Hindi kasi ako abogado, no? I know certain laws, pero magagaling kayo eh. Magagaling kayo eh.
Well, Madam Chair, I would support the suggestion of Manong Benny, Chairman Abante, about creating a TWG. However, Madam Chair, there's no bill that was referred to this committee that has a separate version when it comes to EJK. So, isa lang po. So, but when Makabayan, maybe by the time that Makabayan proposes their version of EJK bill, and I guess that's the time that we can consolidate it, perhaps we can create a TWG. But if it's only about the matter of defining what constitutes EJK and perhaps including that phrase yung nagustuhan ko rin po, unrestrained killings. Then with all due respect to naman, kasi gusto ko po mas mapasa na natin to sa mas madaling panahon, it will cause more delays. So maganda na po at for my own personal take, maybe this kind of settings po
we
good
can
enough.
have another hearing.
Yes.
At the next hearing, they can they can refine their suggestion.
Yes.
Huwag na lang PWG. Okay lang yun. Para maging madaling ma-approve. In fact, we can now approve it in toto.
Kung Benny, so you withdraw the motion for now?
It's just a suggestion to me kasi meron kasing sinabi ang OSG na maganda eh. No, it's not actually consolidating some bills because it's only one bill actually. Di ba? Pero yung TWG is just resigning it as you would suggest in the other agencies that we have. And afterwards talking about this, pero sabi, mukhang maratagal lang nga tayo.
We can actually do that.
In fact, the motion I'd like to say, Madam Chair, is to approve this in toto.
I think we need another hearing because we have to refine the bill. But yes. Yes, Conference.
Thank you, Madam Chair. As regards sa definition, no? So, mukhang umaayon sa iniisip po namin yung definition o yung description ng EJK. Alam mo yung sinasabi ni Madam Chair ni Congressman Zia, yung tungkol sa merong official na nagbabanta, nagkakaya ng assassin, that is murder. No? Murder yun. Pero yung extrajudicial killings, parang from a policy ng state na ganito tungkol sa halimbawa sa drug on war, meron siyang, yung government official, may nilabas siyang policy. At yun nga, isa na katuparan ng mga enforcers na wala man lang, so lahat na yan, kill. So lahat na makita na, napasama pa yung rewards, di ba? Na aggravate pa dun sa rewards. So yun yung extrajudicial killings na parang lahat na lang ng addict papatayin mo na wala man lang wala man lang benefit ng due process. So yun. Pangalawa, ganun din yung nangyari ni Madam Chair sa mga aktivista na katulad din yan ng mga dahil doon sa EO what's that 80 yung EO 80 rin ng previous administration na tungkol din sa antay naman sa mga communists or sa mga terrorists or whatever. So, basta na lang pinatay. So, yun yung ganun po. Yung extrajudicial killings na walang benefit talaga ng due process. So, yun po. Pero yung murder, talagang meron ka ng meron ka ng parang individual na intent to kill. No? Ito, based sa isang policy ng state. So, yun po yung concept namin ng extrajudicial killings. Whether it is war on drugs or it is war against terrorists or war against activists, opposition, and dissenters. Thank you, Madam Chair.
Yes, from the PAO po. Good afternoon, Madam Chair, and to the other members of the Honorable Committee, as well as all of us present here. Firstly, the Public Attorney's Office, Your Honor, process no objection. In fact, it's pursuant the passage of the bill under consideration, as this is consonant with the Constitution. And also, the PAO can render free legal services consonant to its mandate, Your Honor, to indigent persons as well as other qualified persons in civil, criminal, and admin cases, Your Honor, subject to our regulations and existing policies as regards to merit tests and indigency tests. I would just also like to voice out my personal opinion, Your Honor, with respect to the matters in consideration. I think I would like to subscribe to the idea that personally, the EJT be considered as a qualifying circumstance under the provision of aggravating circumstance. And if my memory serves me right, we are legislating here, focusing or talking about a specific crime with respect to EJK. The problem is, during the trial, if the prosecution fails to prove the element that it is state-sponsored or through the intervention of any public officer, then what will happen to the case?
what will happen to the accused? He will be acquitted. So I think we have to focus on the criminal act. I don't know if my understanding is correct, although we have a supplementary provision with respect to the proposed bill that that RPC will be supplementarily applicable in this case. I don't think the case will be downgraded to homicide if the prosecution fails to establish sufficient evidence to prove that there is EJK. Unlike, for example, in murder, if he fails to prove the following five circumstances of treachery, then it will be downgraded to homicide. That's all, Your Honor. Then we can also legislate a separate bill with respect to reparation. It's qualifying circumstances.
Arlene was going to file a separate bill on reparations. She mentioned it to me. Pero hindi niya pa na.
Madam Chairman, I am just bothered by the previous statement of the OSG. And now it's coming up again by the POW about reparation, making it a separate bill. Is that what you are saying, Madam Chair?
Yes, parang may suggestion.
But it's not reparation. Part of the accessory penalty whenever there is a conviction or a judgment in a case. If you look at Section 38 of the Revised Penal Code, it's one of the pecuniary liabilities of a person accused of a crime. And whether it's reparation and indemnification. So why are you saying now that there is no reparation if we do not make this a law and just make it a aggravating circumstance that will make it murder, and therefore a penalty to be meted is reclusion perpetua. So what difference does it make? Is it your admission now that is it your position now that there is no reparation in this measure if we do not make that a EJK bill, EJK law?
Your Honor, sorry.
Go ahead.
The concern that we raised earlier was just that, but I understand, yes, we understand, we see where the good lawyer from the public attorney's office is coming from. But what we said earlier lang po was that if we don't couch it as an EJK anymore, why will we have a reparations board for EJK victims when when we will just make them murder victims? So will we have a reparations for murder victims specifically for this aggravating circumstance? But to answer po, Panero, we agree. We see, yeah, that's right. We see where you're coming from. Kasi generally, hindi nga mada-downgrade, no? But that's a good point in the sense that we could perhaps include po sa draft bill something to the effect like, let's say, the revised penal codes is still could be applied suppletorily or something to the, there is, okay, but something to the effect of my colleague here mentioned, di ba po, like sa 7610, acts of lasciviousness and everything, di ba pwede siya, depende how the information is couched, di ba, if we can't prove the elements in 7610, as long as the information is couched broadly enough to also include the elements in acts of lasciviousness and RPC, pwede pa rin siyang ma-convict doon. Hindi ba, Panero? Please correct me if I'm wrong. You get what I'm saying? Like 7610, acts of lasciviousness, RPC, as long as the information is couched in a way that pasok pa rin yung elements ng RPC, acts of lasciviousness, pwede pa rin siyang ma-convict sa acts of lasciviousness under the RPC if hindi na-prove yung 7610.
Okay.
And not
Yes, I also agree. So long as there is a clarification or there is a specific or clear provision stated in the proposed bill.
Yeah.
Because if you're going to, well, compared to cases filed in court, there's a mention there that this particular accused is being accused of for violation of in relation to RA 7610. So he is fully informed of the nature of the case filed against him. Yeah, that's it.
Yeah, that's a good suggestion. Something like that. Okay.
Kung Zamora? Okay. Nag-i-enjoy kayo na lang nag-uusap. Nakalimutan nyo na. Okay.
Madam Chair, so
Yes, Chairperson.
Madam Chair, so is it now the position, is it still the position of the OSG that we should go ahead with this as an EJK bill or law? So not accepting or giving a prospect that we can just make this as an aggravating circumstance?
Okay.
So what is the position?
OSG? Pakisagot yung tanong ni Kong Acharon.
Madam Chair, Your Honor, state solicitors lang po kasi kami, but we will bring that up po to our surgeon.
Anyway, we will have another hearing. So maybe when you come back next time, you will consider these questions, no? These issues. Sige.
Sure. Because I'm mentioning about the surgeon thing or appearance in this committee. Earlier, your office is represented by two associate solicitor. Now, you now come in full force with your two state solicitors. I think three now. So I hope we would be able to hit the reminder or the warning of the chairman that when there is a committee hearing like this, we should be favored, the committee should be favored with the appearance of the head of office so that we can have a speedy disposition of relevant or material issues pertaining to the legislated, what are the things that we are legislating here in the committee.
Yes, because earlier today, the OSG representative could not answer any questions. In our invitation, we allowed authorized representatives to appear instead of the head of agency, as long as that authorized representative can answer the questions of the committee members. So I issued a warning to the OSG that next time we won't be so kind. If you know what I mean.
No.
Yes. That's why we are happy that you are participating and answering our questions. Kasi kanina walang masagot yung taga OSG. They came from your office. I don't know if under you or
No. Madam Chair, what happened is that they said the position paper of the OSG was not yet finalized. That's why they were hesitant to speak up or provide any comments.
But it says in our invitation that you should be able to answer the questions.
Yes, Madam Chair, just to explain po how it goes po in the OSG po kasi, like for example, the bill on the civil forfeitures is assigned to 2 divisions. And then this bill on EJK is assigned to 2 divisions. That's the division I belong to, and Ellie belongs to the 2nd division. So we were assigned by our ASGs to attend today, as opposed to the 2 divisions regarding civil forfeiture. That's who they assign.
In other words, mas magaling yung division ninyo.
Parang ganun na po. Joke lang. Strike from the...
Okay. Anyway, OSG, wala na kayong, so far, yun na lang yung ano nyo muna, no? So that we can listen to the other resource persons also. Anyway, we'll have a second hearing eh.
We don't contact.
Okay. Sige. CHR.
Good afternoon, Madam Chair, Your Honors. Our apologies because we did not yet submit our position paper on this bill, but I was instructed by my chairperson just before I came here that because the term itself, EJK, is under consideration by the SEB come Friday, and likewise the definition or the description. But in the Commission on Human Rights, we already have what we call our definition in our glossary, and during the 5th Commission, we also have our description or the list of cases under EJK, but focus on the drug war, but we already have a stand on the EJK claims board. If I may be allowed
Can you
to.
share it with us, please?
Yes, Your Honors, we will.
Meron sila.
Our definitions, Your Honor, the EJK and that of the EJK under the Fifth Commission. But before proceeding, Your Honor, may I just be allowed to comment on the explanatory note considering the report of the Commission on Human Rights was quoted. This is with regard to the numbers actually. Yung last part lang po, because this is a report focusing on the extrajudicial killings that we investigated during the time of the Fifth Commission. But it says here that we only investigated 846 cases. But actually, Your Honors, during that time, we investigated 3,805 cases of EJKs, but this report more or less took samples of these cases because it would really be a gargantuan task if we will really assess all these cases, this almost 4,000 cases. So actually there were 822 sample cases. So baka pwede pong i-correct lang considering this is actually an official report of the Commission on Human Rights.
Yes, Madam Chair, we took note of the observation of CHR, Madam. We will do the appropriate correction, Madam Chair.
Thank you po. Okay. The Commission generally supports and welcomes House Bill 10986 as a pivotal step toward ensuring the primacy of human rights and the inviolability of human dignity. But with regard to the term and that of its definition, we have yet to submit our position paper, Your Honors. But with regard to the creation of an EJK claims board, we already submitted our position paper in previous committee hearings, Your Honor. So I would just read, if I may, the recommendation of the Commission on the Claims Board. The Commission strongly advocates for the proposed establishment of Claims Board as an essential mechanism for recognizing and addressing the harms suffered by victims of extrajudicial killings and their families. Nonetheless, the Commission emphasizes the critical need for the Board attached to the Commission to operate as a separate and independent entity. Because looking at the bill itself, parang under po kasi siya sa one of the units of CHR. Parang this one is akin to the Human Rights Victim Claims Board para po for operational efficiency, and considering we do not have the human resource really to, how do you say this, tackle all the applicants or the claims of the victim's family. As an independent but attached claims board, it will allow operational efficiency by leveraging the Commission's resources, expertise, and institutional support while maintaining autonomy in decision-making. Furthermore, an independent claims board aligns with the principle of checks and balances. It provides victims and their families with confidence that their cases will be handled with integrity and impartiality, which is especially important in addressing sensitive and complex human rights violations like extrajudicial killings. We also have our other recommendations, additional, not stated in the proposed bill po. Transparency and accountability measure. The Commission recommends the inclusion of additional safeguards such as mandatory reporting of EJK cases to the CHR, to ensure the principles of transparency and accountability are upheld in every stage of the investigative and prosecutorial process. Likewise, the Commission emphasizes the need to ensure that proposed law includes provisions mandating rigorous independent investigations and the protection of witnesses to guarantee the integrity of the prosecution process. That's our with regard to the claims board. So we really would want it to be attached but independent to the CHR.
Just to clarify, yung sinasabi mong board, is that already existing?
Yung pong dati po, it is akin to the Human Rights Victims Claims Board po. So nag-ano din ang commission doon, separate po siya sa amin.
So, can you submit that in writing so that we can...
Yes po, we will.
Thank you. Next, National Security Council, may representative.
Sige, okay.
Good afternoon po, Madam Chair, members of the committee, and our colleagues from the government service and other resource speakers in the House po. Good afternoon po. From the National Security Council, we have already submitted our position paper
Please
last...
identify yourself and your designation.
Sorry, I am Attorney Angelica Gonzales, a legal analyst po of the National Security Council, together with me, Director Monico Batle, Director of the Security and Clearance.
Okay, please proceed.
All right. Madam Chair, we already submitted our position paper last December 3, and we do join the manifestation that there might be a need to reword or recalibrate the meaning of EJK under the present bill po.
Did you, in your position paper, was there a suggestion as to the definition?
We did not include a definition, our own definition po of EJK, as we want to consider and to hear po other definitions coming from other...
So now that you've heard the other agencies, can you submit a suggestion for the next hearing?
Yes, Your Honor, we will submit our own definition.
Kong Zia, do you have a question?
Yes, Madam Chair. I'd like to know what's the position of the National Security Council. Do you interpose no objection? Do you support the bill?
We do support po this effort, but we interpose on that there's a need to reword or recalibrate for the meaning of the EJK.
I think that's a common opinion of all the agencies that we have heard so far, that they just want to refine the definition. Sige.
Madam Chair,
Yes.
I do not have any problem in refining the definition, no? Pero palagay ko naman malinaw na ang kaibahan dito sa murder, yung illegal order Di ba? Yung illegal policies is actually unconstitutional. And that is what is the difference between EJK and murder. Yung qualifying sa murder, kasama dun sa EJK Ang pagkakaiba lang nito, ginawa ito ng mga agents of authority on the basis of an illegal policy, legal order. Yun ang pagkakaiba
Okay, so...
Let me ask Madam Chair, the OSG, what they think about what I said.
Back to OSG tayo. Favorite kayo ngayon ng mga members, sige.
Sir, since medyo major po yun, decision siya on our part, I think we have to confer with our office first. And then we will, all your suggestions and are noted, and we will get back to you to answer.
For the next hearing,
We would like to ask the OSG, the Commission on Human Rights, for example, the NSA, in not only in submitting your proposals, but also to fast track this, because we do not want to delay the approval of this bill. Kasi 8 sessions na lang kami next year. Oo. Okay, thank you. Thank you, Madam Chair.
AFP.
Good afternoon, Madam Chair, and to the members of the Honorable Committee. The AFP wish to state that we are fully committed in respecting, promoting, and fulfilling human rights. It continually engages with the Commission on Human Rights on reports of alleged human rights violation and submits its personnel for investigation before the concerned agencies, including the Department of Justice, the Office of the Ombudsman, NBI, and the Philippine National Police. By the way, Madam Chair, I am Captain Anthony Cabarteja, the Chief of the Advocacy and Research Branch and Legal Officer of the AFP Center for Law of Armed Conflict. And we appeal to this Honorable Committee to give us sufficient time to consult the other appropriate offices of the Armed Forces of the Philippines
to present our official position on the subject. The process of obtaining inputs, subsequent deliberation, and drafting of official position on the matter may take a longer period for the Armed Forces of the Philippines. This is why we venture to give our initial inputs to the House Committee during the hearing to put context on our stand to the proposed bill. May I just share one question, Your Honor? If a public official committed killing in official capacity or not in official capacity, is it considered as an EJK?
Under the definition.
Napakadaling eh. Under EJK, if he did it
Basta.
on the basis of an illegal order, yun a policy that is against the Constitution, yun ang pagkakaiba doon.
Thank you, Madam Chair.
Lahat ng magsasubmit ng position paper, no? I'm giving you until next week, a week from today. Today is Wednesday. So, kailangan by the 18th, all position papers have been submitted already. Wala nang excuse.
Yes, Madam Chair. We submit it. Madam Chair. Thank you, Madam Chair.
Sige, PNP.
Madam Chair, good afternoon. To the other members of this committee, another resource person, good afternoon po. From the PNP side, ma'am, we are in support of this proposed bill. However, we have these following comments and recommendations for consideration. And may I be allowed to read, ma'am?
Sige.
While the bill characterizes extrajudicial killings as deliberate and arbitrary killings that lack the authorization of a prior judicial judgment, it is strongly recommended to establish a clear legal and conceptual distinction between EJKs and other crimes such as homicide and murder. This differentiation is essential for understanding the gravity and unique implications of actions committed by public officers in the performance of their duties as opposed to ordinary criminal acts. There is often a blurred line between legitimate law enforcement activities, such as arrest or acts of self-defense, and instances of extrajudicial killings, particularly when excessive force or procedural lapses are involved. In such situations, the intent and context of the actions must be carefully examined. The proposed bill should address the critical legal issue of determining whether a death resulted from an intentional act of unlawful killing or was an unintended consequence of a legitimate operation. Establishing clear guidelines in this regard is essential to ensure fairness and accountability. And lastly, on the provision of under Section 9, which titled Presumption of Administrative Negligence, we respectfully suggest the establishment of a clear and objective parameters for the Commission on Human Rights in assessing administrative negligence among public officials in relation to EJKs. Such clarity is crucial as the presumption of negligence carries significant implications for public officers tasked with maintaining order and safety. Properly defined parameters will help prevent undue presumption of fault while ensuring accountability for genuine lapses in duty. That will be all, ma'am, for the PNP.
Is that a written position paper?
Not yet, ma'am, but we will submit.
1 week, okay?
Yes, ma'am.
Next, NAPOLCOM, and then we'll listen to NUPL and Karapatan. So, NAPOLCOM, may representative ba dito?
Good afternoon po, Madam Chair. Attorney Bustonera po, Director for Legal Affairs of the NAPOLCOM. Our apologies for not having submitted a written position paper, but kindly allow me to discuss our position po on the matter. Firstly, allow us to state for the record that we support the passage of the proposed bill, which provides for a comprehensive legal framework to combat extrajudicial killings. We submit 3 points for consideration of the committee. The first one is on the presumption of administrative negligence. Similar with the position of the PNP, we would like to state that it is our recommendation that a clear delineation and factors be stated to quote-unquote quantify an increase in EJKs. We recommend that a baseline or threshold number of incidents be established. If not, a specific time period during which the increase must have occurred should be established. And third, there should be a clear criteria for determining whether the increase is attributable to administrative negligence rather than external factors. Second, on the aspect of administrative negligence as well, we would like to clarify whether the public officers intended to be charged with administrative negligence should include public officers in charge of public order and safety and the local chief executives, or are they in the alternative? We take note of the fact that local government units have their own departments of public order and safety. So will the department head of the depots be charged in case there is noted increase in EJK in the specific areas? And thirdly, ma'am, with respect to the discussion on preventive suspension, this is not pending criminal action. This is not a new matter. This is actually provided in Section 47 of RA 6975 and discussed by the Supreme Court in the case of Himagan versus People of the Philippines. To quote the Supreme Court, it states there that the reason why members of the PNP are treated differently from other classes of persons charged criminally or administratively insofar as the application of the rule on preventive suspension is concerned is that policemen carry weapons and the badge of the law which can be used to harass or intimidate witnesses against them. If a suspended policeman criminally charged with a serious offense is reinstated to his post while his case is pending, his victim and the witnesses against him are obviously exposed to constant threat and thus easily cowed to silence by the mere fact that the accused is in uniform and armed. Thus, the imposition of preventive suspension for over 90 days under Section 47 of RA 6975 does not violate the suspended policeman's constitutional right to equal protection of the laws. Thank you, ma'am.
Thank you. So next,
Madam Chair, let me respond. That's the reason why we need the EJK. Diba? Napolcom, nasa inyo ba? Nasa ilalim niyo ba ang yes?
No, sir. The ES is under the office of the Chief PNP.
Okay.
Yes.
okay. So next, the NUPL.
Good afternoon, Madam Chair and the members of the committee. Thank you for inviting us. First, we welcome the introduction of this bill because we believe that it is the opportunity for us to fine-tune the distinction between murder, as currently defined in the revised penal code, and extrajudicial killings. And based on our abundant experience as lawyers for victims of human rights violations, including extrajudicial killings, one of the key differences lies in the effect, not only in the surviving families of those killed, but also in the communities where they come from. Because when someone falls victim to EJK, it creates a killing effect on the community that victims who are frequently human rights defenders, political activists, and those who voice out their criticisms and dissent against the government. So I think it's very important to recognize that through this law. And I agree with Rep. Abante that we can benefit from going back to the explanatory note as to guide us in further refining the definition of EJK, because here there is a mention of the fulfillment of human rights. And I think it's important to go back to what is at the center or at the heart of this bill, and that is the right to life. And the state is the primary duty bearer in protecting the right to life. That's why when EJKs happen, there is already a violation of the public trust that the state actors and government officials enjoy or by virtue of their office. Now, may we just state we apologize because we have not yet submitted our position paper, but we will within the coming week. But we note that there are several, we would like to share our comments. First off, based on our observation from experience and as according to international law, senior officials may be responsible for EJKs, and it is recognized in this bill. So this is a welcome recognition. And they are responsible not only for direct orders, but also for failing to prevent or punish unlawful killings by subordinates under their control. And this carries two implications. First, in terms of liability. We are pushing for the adoption of command responsibility as provided in the Anti-Enforced Disappearance Law and also under the IHL, the Domestic or the Philippine IHL Act or RA 9851. And also, extraordinary diligence must be required of law enforcement authorities, persons in authority, and their agents in the discharge of their duties so that these officers will be stopped or disabled from invoking the nanlaban narrative and using the use of lethal force to exempt them from criminal liability. Yes, that would be it. For now, Your Honors.
Can you also help with the definition? Do you have any suggestions?
Yes, thank you for asking. Yes, we would like to.
Yes, can you submit your, so that we can consolidate all these suggestions and we can show the authors and maybe we could come up with one that everyone would agree on.
Yes, Madam Chair.
Thank
We'll
you.
gladly.
And then karapatan.
Madam Chair, maybe also further explain to us and maybe put that in your position paper how we can resolve the issue. Kanina po yung sinabi ko kasi yung command responsibility. I think that concept maybe can be properly addressed. At least ma-distinct natin yung culpability nung nagbibigay ng utos, no? I think mas maganda rin po yun na ma-include nyo sa position paper ninyo para ma-enhance further yung bill.
Can you include that also in your...
Yes, we
You
will.
mentioned about the command responsibility. You reference a certain law, di ba?
Yes, to
Okay,
laws, to domestic laws.
Okay, thank you. And then karapatan?
Magandang araw po, Madam Chair, members of the committee. Nakapag-submit na po kami ngayon lang po ng position paper and because of the interesting discussions also sa committee hearing ngayon, magsasubmit po ulit kami para makatulong pa, informed by the discussions of the committee right now. But first and foremost, of course, we acknowledge po this proposed measure as a very important step to define the crime of extrajudicial killings dahil we've been using it for so long because it has happened also for so long. No? And we actually developed our own definition as reflected in our glossary, like Commission on Human Rights po. Meron po kaming human rights glossary as a human rights organization. And sa totoo lang po, we also participated in a similar discussion on the anti-enforced disappearance law. Because, sa anti-enforced disappearance law po, ano yung difference ng enforced disappearance sa kidnapping or deprivation of liberty? Dito po, we think it's the same. So, I'd like to state our working definition of extrajudicial killings. Actually, it's a combination of the existing definition under Republic Act number 11188, the Law on Special Protection of Children in Situations of Armed Conflict, and the elements in the definition of the Anti-Enforced Disappearance Law. Extrajudicial killings refer to all acts and omissions of state actors that constitute the violation of the general recognition of the right to life embodied in international and domestic human rights instruments, which are committed by the state, by agents of the state, or by persons or groups acting with the authorization, support, or acquiescence of the state. So, talagang may sa discussions din po namin noon sa TWG on the Anti-Enforced Disappearance Law, what differentiates it from murder is the imprint of the state. Yung ibig sabihin, done by state actors with authorization, support, or acquiescence of those in public positions. Secondly, we support what Attorney Joseph NUPL said on command responsibility. We have existing jurisprudence po at sa batas din po ng 9851 at saka sa 10353, may mga provisions on liability of commanding officer or superior in the commission of the so-called crime of enforced disappearance or violations of international humanitarian law. So we propose that we consider provisions of those two laws in terms of liabilities, no? And bearing in mind also yung doctrine of command responsibility as defined in the decision of the Supreme Court on the petition for the writ of amparo and habeas data dun po sa kaso ni Noriel Rodriguez. Meron pong dinefine doon ang Korte Suprema tungkol sa saklaw ng command responsibility. Lastly na lang po, yung tungkol po sa provision sa Section 9 on presumption of administrative negligence, may exception po kasing binanggit dyan dun sa areas declared by proper government authority as areas of conflict or combat zones. Tingin ko namin, Madam Chair, may existing law po tayo ngayon, yung tungkol po sa international humanitarian law that covers yung areas or any violation na sa areas of conflict or combat zones. Ito po yung 9851, no? Kaya kailangan po maging consistent po yung proposed bill na ito doon po sa domestic law na existing. Yun lang po. Maraming salamat po.
Madam Chair, salamat sa pagpapaliwanag mo, Ms. Palabay. No? I think it's very important. Sapagkat kung nung pinapanood ko itong hearing nito, may mga comment na akala nila itong EJK na ito ay ginawa lamang specifically dahil lang sa mga nangyari ng past administration. Hindi na eh. Yun ay specifically doon lamang sa mga drug victims. Hindi. Binanggit mo yung human rights defenders, may mga doktor tayo mga pinatay, meron tayo mga media na mga pinatay, meron tayo mga lawyers na mga pinatay. Hindi kasama doon sa dating administration. Ibig sabihin, kung may EJK na tayo, bago yung dating administration, tama, hindi nangyari itong mga bagay nito, no? So, talagang matagal na dapat ng bitas na ito. So, we'd like to find out, kasi alam mo, pinapanood tayo ng taong bayan dito, eh. Gusto ko lang pumalaman ng taong bayan, Madam Chair, na itong bitas na ito, hindi lamang tinutukoy ang past administration. Kundi tinutukoy dito, lahat ng mga napapatay, yan man ay drug victims, yan man ay human rights defenders, yan man ay abogado o doktor, lahat na pinapatay out of an illegal order. Pinapatay po na hindi sang-ayon sa saligang batas. Yun po ang gusto ko lang ipakita sa taong bayan natin. Kaya meron tayong EJK bill na ito. Thank you, Madam Chair.
Are you done? Yes, Ms. Palabay.
Madam Chair, magbibigay lang ako comments sa binanggit ni Kong Abante. Marami pong salamat. Totoo po yun. Bago pa naman po yung nakaraang administrasyon, nagaganap na po talaga yung extrajudicial killing sa bansa. In fact, marami po taong simbahan, mga development workers, kahit po yung human rights workers namin. Kaya malaki din po yung at stake namin dito sa bill na to. Tama po yun. Nagpa-file po kami ng murder, ng kaso ng murder, no? Pero it doesn't quite fit the bill eh. No, kasi hindi naman po ito acts of committed acts of one person to another. These are acts we think of persons in authority, no, dun po sa isang human rights worker who is, you know, documenting and reporting on human rights violations cases. So sa totoo lang po, we think this is long overdue. That is correct. And such a law will not only recognize kumaga put alim, no? Doon po sa dati ay tinatawag na salvaging, di po ba? May tawag dyan, salvaging, summary execution, assassination, etc. But also, it would provide a clear guideline or a standard sa ating pong paggugobyerno tungkol po dito. Last naman po, Madam Chair, nag-agree po kami na yung reparations po ay magkaroon ng hiwalay na bill, batas tungkol dito. Naging part din po kami ng discussion sa Human Rights Victims Recognition and Reparations Law. Marami pong kailangan sigurong include pa na transitional justice mechanisms doon po sa binubunong reparations bill. At doon po, may standard na din po kasi tayo, yung HRVV. No? So yung mga, ko-consider na lang po kung ano yung, sa manggagaling yung appropriations. At the same time, ang maganda po doon, may relative independence po kasi ang isang claims board na katulad nun na hindi naka-attach lang sa Commission on Human Rights. Dahil as it is not right now, I understand, talagang mabigat na rin yung inaano ng CHR. And then HRBB Claims Board before, na may independent function and operations, nakatulong po ng malaki yon para po dun sa pagbibigay po ng reparations, monetary or non-monetary reparations sa martial law victims. Yun lang po.
Thank you.
Madam Chair,
Yes po.
kanina binanggit ni Ms. Balaba yung compensation, no? Yung reparation. Narinig ko yung tanong ng DILG kanina. Saan DILG? May nagtanong kanina kung saan manggagaling ng reparation. Please, manggagaling sa inyo ang reparation. Natural, di ba? Pag AFP, pag sundalo, manggagaling sa AFP o Department of National Defense. Huwag kayong mag-alala. Pag naging batas to, we will provide the funding for that. Sa inyo mga ahensya. Kaya huwag kayong matatakot magbigay ng reparations. Okay?
I think sa bill ninyo, Kong Benny, merong appropriation provision, yes. Okay. So last three na lang tayo na na agencies, NBI, PAO, and then last of course yung DPM. NBI, please identify yourself.
Good afternoon, Madam Chair, and to the honorable members of the committee, and also those who are present in this committee hearing. Our apologies, Madam Chair, that we haven't yet submitted our position paper. Madam Chair, may I be allowed to read some of the
Yes, go ahead and you can.
it is from position paper, Madam Chair.
Yes, go ahead.
Extrajudicial killings or extrajudicial execution is a deliberate killing of an individual by a state agent or with their consent without previous judgment affording judicial guarantees such as due process and impartial procedure. The form of killings is contrary to the legal obligation of the state to protect the right to life. Such arbitrary deprivations of life often target political opponents, activists, or marginalized groups. In our jurisdiction, extrajudicial killings were rampant during the war on drugs. It targeted the drug dealers and users. However, as can be gleaned from news reports and ongoing investigation, most of the victims of the war on drugs were the poor. Most of the victims of the anti-drug campaign were people in the low-income bracket or the marginalized groups. The apparent disregard of this fundamental right by the state, who is tasked to protect the life and liberty of the Filipino people clearly indicates the decline of the morality of the government officials and law enforcement agents, resulting in the loss of confidence by citizens in the justice system of our country. In view thereof, the National Bureau of Investigation, the premier investigative agency of the country, is an ardent supporter and enforcer of state policies to maintain peace and order, protect life, liberty, and property, and promote the general welfare of the Filipino people. Extrajudicial killings present a threat to the inherent right of every human being, the right to life. The NBI firmly believes that House Bill 10986 will help in upholding the right of every person to have his life respected and deter the arbitrary deprivation of this fundamental right. The House Bill will strengthen the commitment of the state under international law to protect, respect, and fulfill human rights, which entails the protection of individuals and groups against human rights abuses. It is mandated that in the performance of duty, the state law enforcement agents shall respect and protect human dignity and uphold the human rights of all persons. No law enforcement agent shall inflict, instigate, or tolerate extrajudicial killings, arbitrary arrest, any act of torture, or other cruel, inhuman, or degrading treatment or punishment. The NBI hereby expresses its full support to the House Bill, which will classify and penalize extrajudicial killing. Rest assured, the NBI will continue to uphold and advocate the right of every individual to life. That's all, Madam Chair.
Once again, with us, Your Honors, I would just like to reiterate our position, Your Honor, that our Lord to honor the Honorable Committee in its effort to pass this particular legislation, Your Honor. That's all, Your Honor. Thank you, Your Honor.
Lastly, DBM.
Good afternoon, Madam Chair. I'm Trisha Barante from the DBM. The honorable members of this committee and to our fellow public servants. Regarding to this bill on the organization, we respectfully suggest po to review and assess and harmonize po the functions of the existing bodies po. Kasi under the DOJ, meron na po tayong Board of Claims and sa CHR to ensure po to identify the gaps, to ensure na wala pong overlapping ng functions and areas to be strengthened, and of course, duplication po ng funding for the purpose. Kasi currently, under the CHR po, mayroon po tayong financial assistance to victims, which I think overall naman po this pertains to human rights. And under the budget of the DOJ, meron din po tayong funding for implementing Admin Order 35, which includes extralegal killings po. So, yun po yung first on the organization. And then, on the funding requirements po, we take note po under RA 7309, ang funding source po niya ay from PAGCOR and yung proceeds from disposition of military camps in Metro Manila by BCDA, etc. Para po hindi ma-bloat po yung ating fiscal space kung sa GAA po siya ilalagay, especially hindi naman po natin alam, hindi naman po siguro yearly may claims po yung reparation for the victims. So baka we can consider po as funding source itong under RA 7309. That's all po.
Anyway, that
Madam
will
Chair.
that will have to pass the Appropriations Committee. Yes,
Madam Chair, I'd like to ask DOJ, is it true meron pala kayong compensation reparation board for victims of extra legal killings?
Yes,
ano yung sabi mo niyo po, DBM? Extra
I was
Tricia?
gonna ask that, Kong Zia, kasi merong interagency committee on extra-legal killings, enforced disappearances, torture, and other grave violations of the right to life, liberty, and security of persons. Bali, interagency yan, pero ang lead agency is DOJ.
What exactly do you do? Kasi this one is very specific, Madam Chair. Kasi we are trying to define legal parameters on what EJK what constitutes EJK. Yes.
Honorable Chair, if I may po.
Yes, go.
Regarding po sa comment ni DBM regarding the claims board, ito po yung RA 7309. However, it does not specifically mention po yung EJK lang, but it pertains to victims of violent and heinous crimes. And on the other hand naman po, yung binanggit po na AO 35, it was issued back then nung time pa ni President Pinoy, which is the creation of an interagency committee on extralegal killings, EDs, torture, and other grave violation of human rights. We have issued its operational guidelines in 2012, wherein it defined where it uses the term extralegal killings. If I may read.
Maybe, yes, Madam Chair, the way I understand it, Madam Chair, is that extralegal killings may be a result of a torture, no? Parang, I don't know. Pero kasi ito, extrajudicial killings is primarily, it's essentially, Madam Chair, about killings, those allegedly na mga ano na hindi binigyan ng due process, na hindi na kuhanan ng korte. Tama ho ba, DOJ, no?
Well,
parang ganun yung sa inyo?
That's one of them, pero meron din sa definition niya, meron ding, if the person responsible for the killing is a state agent or non-state agent. So, nandun din yung person responsible sa definition nila na extra-legal killings.
Tama po, tama rin. Yung, the same ba? Like yung sa extrajudicial killing, essentially, parang, ito yung pag allegedly, no, kasi mga biktima supposedly dapat sinasabi nila may mga criminal din, so pinapatay, yung iba hindi nakakasuhan. Ibig sabihin hindi siya dumaan sa proper procedure na kung saan yung due process ay na exercise or na observe nung the same ba yung sa inyo diyan sa interagency ninyo? Ay, sorry.
Extralegal killings refer to, it identified the victims, such as when the victim is a member or affiliated with an organization, affiliated with the political, environmental, labor organizations, advocate of such causes, or those who are mistakenly identified regarding such, or another one is the victim was targeted and killed because of actual or perceived membership, advocacy, or profession. The responsible or the perpetrators are state agent or non-state agent, and the method and circumstances of the attack reveals a deliberate and intent to kill. That is our, based on AO 35.
Thank you, Madam Chair. Thank you.
Any other questions from?
Gusto ko lang kasi na ko doon. So, ibig sabihin, do you have a board and do you also address reparation? Have you actually released mga actual reparation? Kasi that's di ba tama we are 33 siya, no? Yung sinabi nyo? The board is also mandated?
Yes po. Good afternoon again, Madam Chair. We have under 7309 po, RA 7309, meron po kasing Victims Compensation Fund po. And we actually release po funding for that. May mga release po previously. So, ang concern lang po namin, baka madoble po yung funding and yung duplication ng functions po nila. Para ma-clear lang rin po kung sinong gagawa ng different activities.
Thank you, Madam Chair. Gusto ko lang clarify.
Any other questions? Yes, Conference.
Madam Chair, siguro sa susunod na meeting, magbigay ng report siguro yung DOJ kaugnay dito sa mga cases na indinulog sa kanila at ano yung mga nangyari. No? Kasi ito na yun eh. Oo, yun.
See, you mean?
Oo. Oo, kung merong actual ba na na reparation no? O tapos yung pong ano na nangyari, may na-prosecute ba? O may naano kayo? O lahat po dismiss? Mukhang baka lahat po dismiss yung mga idinulog ng mga kababayan natin na biktima according to this AO 35. And another one, Madam Chair, yung NBI, so kung meron silang report about doon sa EJK, be it drug or mga activists, mga human rights defenders, baka makapagbigay din sila ng ulat
Can you
sa atin.
submit the reports by next week? Or before, at least definitely before the next hearing?
Madam Chair, what we have submitted to the Quadcom is the overall total cases. Can we submit that documents this committee, Madam Chair?
Yes, submit. Yes.
Yes, pero Madam Chair, parang kung sa EJK war on drugs, parang may 52 lang sila eh. Sa pagkakatanda ko yung mga naimbestigahan. Pero meron akong natatandaan noon na meron pa silang i-update. Doon sa dati nilang chief, Madam Chair, no, yung dati nilang director ng NBI. Parang merong bago.
Can you check that?
Madam Chair, we have submitted a document. The total cases investigated by the NBI is 426 cases. The 52 non-laban cases referred by DOJ, and another 250 cases from the second referral of the DOJ for investigation, and walk-in or those who came to us to have to seek for an investigation is 81 cases, Madam Chair.
Okay. Pakisubmit na lang yan, Madam
Can
Chair.
you submit that in writing? Pati yung sa DOJ, sa interagency committee on extra legal killings. Yung tinatanong ni Kong Zia kung ilan na yung actual na rep. Yeah. You can just submit it to us. You don't have to answer it now.
Once
That would constitute, Madam Chair, na parang, and the implication is that talagang yung alleged na gumawa nun ay guilty siya dun sa crime. Kasi bakit ka magbabayad kung hindi naman, ano. So gusto ko lang malaman how do you determine that? Would you need any court decision for you to be able to release this compensation, reparation? Thank you, Madam Chair.
With respect to the AO 35, it is composed of the law enforcement and investigation cluster po ng Department of Justice, which is under the National Prosecution Service. What we will do, from the legal staff, we will coordinate with AO 35 Head kay Assistant State Prosecutor Gino Paulo Santiago for the...
Invite them next time.
Yes, ma'am. It is better po na ma-invite po sila sa prosecution.
Okay. Any other?
Dagdag ko na lang, Madam Chair, kasi puro droga yung sa NBI. Meron ba silang naimbestigahan on extrajudicial killings on human rights defenders, mga activists, mga dissenters? So,
AO 35.
hindi. Aside from sa AO 35, baka merong separate din yung NBI na naimbestigahan tungkol dyan.
NBI, can you submit? Okay, we'll ask them to submit it. Anything else from our members?
Madam Chair, there being many things to be discussed, I move to suspend the deliberations.
There's a motion to suspend the deliberations of House Bill number...
One. 10.
Then 986, there being no objection, the meeting suspended and the deliberations on the House bill is hereby suspended. Thank you.